should know. I have never really liked you at all. I cannot hide it anymore. I've been thinking about the future, trying to forget about the past. So many ways that I could change for the better.
is a true crime discussions channel. We speculate. This is all just speculation. Because it's true crime, it's for mature audiences only. There will be no children allowed, no exceptions. Everything on this channel falls under fair use. Please remember to like, comment, subscribe, and share. It's free.
Hey, y'all. Hey, everybody. Welcome in. It's good to see you. We've got some really important things to talk about today. Very important. But first of all, the most important thing, I do want to advise you real quick to turn your headphones down if you're wearing earphones, because I don't want to bust your eardrums. I'm going to give you just 5 seconds to do that. And this is very extremely important. And so we need to do this real quick. So hopefully you've got your stuff turned down. Here we go.
Happy birthday to you.
Happy birthday. I think that is so cute. That was like the cutest one I've ever seen. Happy birthday, Abellis. We love you. I hope you're having a good day. Happy birthday. Happy birthday. We love you so much. I'm so glad that it's your birthday. Happy birthday. I love that. It's so cute to me. It almost makes me cry. It's so cute. Happy birthday. Okay, so let me say hey to y'all. Hey, Beach Bum, Bad Girl, Snaggle Mama, Anna, Carolina, Abellis, happy birthday. Fred, Overprotected, Beach Bum, Overprotected, I'm going to share your channel tonight. Cara, Sue Joy, Jenny Jen, Anders, Artemis Prime, Mandy Lorian, good to see you, hey. Irene, Monica, Ashley, Edith, Lori, Jenny Jen, Hio, Jenna's Gypsy, Brenda P. Thank y'all for being here. Ashley, Cara. If I missed you, comment again and I will shout you out. Foxy, good to see you. Okay, hold on a minute. Okay. So we need to go back to one of the first interviews to start this process. There's been some documents entered and they might have a chance of going through. And if they go through, basically, we're not going to have a case for the CSAM trial. So we're going to go back to this interview. I'm going to play 2 timestamps and then part of another interview. And I want you to listen and see if you can figure out what constitutional right was violated, because there is something in this that could be a violation. Hey, so hard to see. Good to see you. Okay. So we're going to go to the February 27th interview of Stephan Stearns. I'm going to play part of this, and then we're going to play part of this one, and I want you to just listen, and then I'm going to tell you what the issue is. Hold on just a minute. Hey, it's meow or never. I like that. It's meow or never. We're going to go back to 21. It does have to do with his phone. I'll tell you that.
Was right here in this stretch area.
Around this area. Okay. Which was before the underpass.
Correct. Before the underpass, just before the church. The church was ahead on the left. The underpass was just beyond that. The school is just on the other side of the underpass. So maybe
on the left-hand side.
Maybe a block away.
Okay. And you said that that's typical of her to walk that distance?
Yeah, she likes the morning walks when it's cool. She doesn't like being seen getting out of certain cars. Being a middle schooler, it's an image thing.
Foxy, have you read the documents? I hope that. I mean, I don't want to trip, but I'm kind of concerned. And we're going to read through some of the documents. I don't want to bore y'all to death with documents, so I'll put a video out later reading these documents, but we're going to talk about some of them. But I am genuinely concerned. Hey, Hazel Eyes, good to see you. Thank you guys for telling Abellis happy birthday. She's so special and loved. Thank you. You guys are awesome.
And she will sometimes like to hang out and wait for her friends. She's known to do that.
Basically, yeah, if they get granted the motion to suppress the evidence that they got from the phone, they've got to prove that he was abusing Madeline some other way than by using his phone and his Google account. Now, you tell me, how is that going to be possible?
Do you mind if I just take a picture of your history?
Yeah, that's fine.
And that time would have been, you said, around
Sorry, I don't mean to keep pausing. Bellis is a very beloved dog that someone had in our chat. I'm not going to say her real name, but she's a very beloved dog. The person who owned the dog is the person whose birthday it is today.
around
8:20ish, 8:30, sometime between 8:20 and 8:40.
What time does she go into class?
She has to be there no later than 9:50.
I promise I won't pause it after this and we'll just listen. But what Carr said is really important. They would have discovered the evidence on the phone no matter what. He willingly handed it over to him. But did he? Did he? Because he might not have. Hey, Chaz. Hey, Ashley. Jenna's Gypsy. There's Jennergy that comes in here too. So sometimes I get y'all confused. Hey, Tony Love.
15, doors open at 8. Doors open at 9, I think. And then school officially starts around 9:20 or 9:28, I think.
Okay. And when you dropped her off, is that earlier than typical, later than typical, around the same time?
Earlier than typical.
Really?
We had made really good time that morning, and with the subtraction of McDonald's, we had more time than usual.
Okay.
But she said it was okay. She's very confident, convincing that it would be fine.
And you saw what direction she walked to after you dropped her off?
Yeah, it looked like she was moving towards the direction of the school like she was supposed to.
Was she still on the right side of the road, or did she
She
cross
was
over?
when I left her. Yeah, she was still on the right side.
What kind of phone is this?
S23 Ultra.
I don't know what this.
I was talking away and my mic was muted. I sped it up, but I'm going to slow it down. This is kind of the part where it gets important. So she just asked him what kind of phone that was, and he says it's an S23.
I'm sorry, I barely know how to work it myself.
I'm an iPhone person.
No,
Is it okay if I go in your settings real quick? I just want to see if you're logged on to your Google.
I am not logged on to my Google with that, actually.
Is it okay if I check?
Yeah.
Okay, that's important. She said, is it okay if I go through your phone? I just want to see if you're logged on to Google. Let me not botch exactly what she said. I'm going to play that back.
S23
Hey, Lily.
Ultra, I think.
I don't know how to work this thing.
I'm sorry, I barely know how to work it myself.
I'm an iPhone person.
No,
Is it okay if I go in your settings real quick? I just want to see if you're logged on to your Google.
I am not logged on to my Google with that.
So is it okay if I go in your settings? I just want to see if you're logged onto your Google. Rachel said he gave them the phone willingly. He could have said no when the first female officer asked, quote, I'm going to keep this. He asked for how long. That's an issue. There's going to be an issue with that when we get into these documents. And I'm a little bit concerned. Cara, thank you so much for gifting 10 memberships. That was so very sweet and supportive of you. Thank you. That went to Know That. Did you know that? Did you know that that membership went to Know That? Courtney got one. Carolina got one. Yay. Monica, always late. Smokey Joe, Stephanie's, JK, Vanessa, Eileen, Kim Trelia. I think that's it. Those are the people who were gifted. If you were gifted a membership from Cara, please tell her thank you. That was so sweet and supportive of you. Thank you so much. That was so sweet. I'm going to pick y'all up on the crazy train headed to Speculation Station.
I'm going off the rails on a crazy train.
Oh, sorry. I was taking a sip of my coffee. Thank you, Cara. That was so sweet of you. Thank you. Hey, Content Angel. Good to see you. Veronica, good to see you. Artemis, you are green. Yes. That means you've got, you can look at the members only videos of mainly of Basil.
Actually.
Is it okay if I check?
Yeah.
Does she have any other devices besides that phone? Any other electronics?
She had her school laptop with her.
Okay. Is that still supposed to be with her?
Still supposed to be with her, yes.
Okay. And what kind of book bag was she carrying?
Black book bag with like grayish blue hibiscus flowers on it, like a print.
All right. I'm going to go ahead.
When she leaves in the mornings, where does she usually put her phone?
Either in her backpack or like her back pocket, kind of wherever she just thinks to put it at the time.
We're going to go to here where they start talking about the phone a little more.
The front gate.
They were there when I came through. He scanned my ticket.
So would it have not just made?
Oh, Elizabeth, thank you for saying thank you. If you got it today, it was Cara. That was so very sweet of you. Thank you for listening. I listen to YouTubers when I do my chores as well. Lily said the way I heard it was he allowed them to have the phone. It didn't appear they forced him, even by threat. She was like, you can allow me or we can get a warrant, which is legal, right? That's an issue, though. Could you say that if somebody told you, you can allow me or I can get a warrant, which is legal, like, would that make you feel pressured to give in your phone, even though you have a constitutional right to say no? That's going to be a big issue in the documents we go over, because they're going to argue that he felt pressured, like he didn't have a choice in the situation because she said, you can allow me or we can get a warrant. And there's a lot more in those documents we're going to go over. So hard to see, said I'd say get a warrant. Yeah, I would too, just for reference. I'm not, I back the blue 100%. But if you ever find yourself in a situation, ask for an attorney, tell them to get a warrant, all of the things. Irene said his dad willingly handed over his flash drives and the old computer hard drives. Those were just as incriminating. Good point. I don't know if there was pictures of Madeline on there, though. But if the CSAM evidence were to get thrown out, maybe they could still prosecute him for that. That's a good point.
It made more sense to drop her off and
Monica,
come back since security's already there.
I don't know if it made more sense. It's just what I did.
Okay.
you're so sweet.
Oh, thank you.
Anything else that we haven't asked that you feel is important? Maybe that might help us out.
I'm sorry. I'm having trouble recollecting everything.
I'm going to step away for a second.
Anything that you remember maybe she might have told you?
She didn't mention anything in particular. I made a joke about her Crocs. She wears Crocs and socks.
Me
We
too,
were
Clark.
joking about that.
Would she say she's usually like a happy, go lucky girl?
Very happy. She brings a lot of joy.
Veronica said, I was watching a video right now by Explore With Us, or EWU, good channel. They are a good channel. They have a lot of good body cam footage, and I'm hoping for Maddie's birthday stream to be able to review the video they put out, because from what I've been told, they picked up on a lot of things that not everybody else picked up on, just like Grish, and the audio was clearer. So I'm hoping for Maddie's birthday stream, we can go over that. MB, thank you for being here, said, not a lawyer in any way, shape, or form, but if you ask me, the only thing that forced him was his own guilt and desire to appear innocent. Good point, and I'm with you on that. Hey, Nessa UK. Snuggle Mama said he wiped his phone, thought it was safe, now he's crying. Yep. Lori says she only asked to see Google, but she obviously looked at call logs, etc., without permission. That's really important. That's very important. I'm guessing the reasons for his attorney's motion to dismiss evidence on his phone because it will bias the jurors, especially with images of the bestiality in the CSAM. Yeah, and for a CSAM trial, if that motion is granted, is there even a case? We're going to talk about it.
She's a very good girl. It definitely doesn't feel the same around here if she's not here. She was so happy too.
I have
She was looking
41.
forward to my visit here. She was looking forward to us all being together. She was just happy. She was just very happy.
Got it right here.
Usually with like her cousins or her friends, and they'll all be playing Roblox or something, and, you know, yelling at each other on the phone.
When's the last time y'all lived together?
December.
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 And you said the reason was for your parents down there.
Yeah, going down to help them because they're getting on in age and they're making their end of life plans and they need someone to help out.
Can you unlock this one more time?
Sure.
I have a question.
Yes.
Sorry, are you guys done?
No, we're good.
The other detective mentioned that you did not have your phone yesterday.
Correct.
Tell me about that.
I left my phone at home in the morning too. I was so busy riding her to the door on time that I left my phone. She left her phone. We both left our phones.
Did you have your phone when you went to the smoke shop?
Not the first time after I dropped her off. I was still without it. I got my phone and went back to the smoke shop later when I got home.
And then I also noticed, I was checking your call history. I noticed that you don't have anything before this morning. Is that unusual on your phone?
No, it's a new phone. Stupid. I went to do an update yesterday morning, and I don't know what the fuck. Pardon me. I don't know what the heck I did, but somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts, all my information.
Mm-hmm. What time was that? Do you remember?
Sometime while I was hanging out with Jen. Jen might know. I looked at her and said, "What did I just do?"
Okay.
She might know better. I don't know what time it was. It was when I was here with Jen.
Okay. I don't think I have any other questions. Do you, Louis?
I don't know where my head was yesterday. It was so far up my backside.
That's okay. We understand. In the meantime, while we're waiting for all this to get sorted out, I am going to hold on to your phone, okay? I'll give it back to you when we're done. Okay? Do you have any questions for us?
How long are you gonna need my phone?
I'm not sure. I'm waiting for my supervisor to call me.
My dad. It's just my dad's using that to get a hold of me and get updates.
They can call Jen's phone.
Okay.
Did the other detective give you his business card?
So with that, I mean, that definitely appears that she's like, yeah, you're not getting your phone back. He even asked, what do I do if my dad calls? I'm going to play just that part over again because it's very important with these documents. Hey, Lemon Lime and Miriam, I think, came in. I'm going to play that part over again. It's very important.
And I don't know what the fuck. Pardon me. I don't know what the heck I did, but somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts, all my information.
Mm-hmm. What time was that? Do you remember?
Sometime while I was hanging out with Jen. Jen might know. I looked at her and said, what did I just do?
Okay.
She might know better. I don't know what time it was. It was when I was here with Jen.
Okay. I don't think I have any other questions. Do you, Louis?
I don't know where my head was yesterday. It was so far up my backside.
That's okay. We understand. In the meantime, while we're waiting for all this to get sorted out, I am going to hold on to your phone, okay? I'll give it back to you when we're done. Okay? Do you have any questions for us?
How long are you gonna need my phone?
I'm not sure. I'm waiting for my supervisor to call me.
My dad. It's just my dad's using that to get a hold of me and get updates.
They can call Jen's phone.
Okay.
Did the other detective give you his business card?
I believe.
So, I mean, again, he doesn't have much of a choice. She's like, I'm keeping your phone. And he's like, I need to talk to my dad. And she's like, well, he can call Jen. He doesn't appear to have a choice in the matter. She knows everything. She's trying to tell us all that she knew everything, allegedly. Yeah. All I need is Jesus. Said he willingly gave them his phone. I don't know what this lawyer's trying to do. Oh, she's trying everything. There's an important part in one document where she talks about the notoriety of this case. And I was like, yeah, you know about the notoriety of this case because you're trying to build yourself a name off of it, in my opinion. Cara said, this is just my opinion, but I think Jen knew and told him to do a factory reset before going down to the station. I think so too, because she references him sitting in the computer chair in her room and says that I told him to do a factory reset. I told him to something. She changes it. It's in the interview where we see her sitting on the couch. I can't remember exactly what she said, but something to that degree. Lori said she told him she's holding onto his phone. Wrong way to go about this, and that's the issue. So we're going to play part of this and then the beginning of the next interview, and then we're going to talk about this document.
Believe so.
Okay, well, here's mine in case you want it for any reason.
Okay.
Okay?
Mm-hmm.
Do you swear that everything you told us is true?
Yes.
Okay, thank you so much. Thanks for your time. We appreciate it. I know it's a little hectic right now.
Hey, Orange Rose. Okay, and this is the other important part of this.
In this audio, we're going to hear several things of
I hate your
importance.
voice.
The first of which being there is a child that Stephan called Poopyhead that him and Madeline are texting late at night. I think they're referring to Stephen Young's daughter.
Okay, let me see what y'all are saying real quick. Y'all got a couple of long comments. So, Misty Moe says they're arguing he granted limited permission just to look at settings for Google Maps. Hate to say it, but they may have a chance for suppression of evidence. Yes, exactly. Miriam said, sincerely, she didn't give him the choice. That might not be a good decision from her part in the sense it might get it thrown out. Hopefully not. Yes, that's the problem. You prefer doing your own thing for your birthday and seeing friends later? Well, I hope that you enjoy today because today is all about you and you do what you want to do, Abelis. Veronica said she even said that it was sus as fuck when she asked about the factory reset, leaving the phone at home, disappearing with her car, meandering at night, etc. Yet she says how she never thought he could be involved. Yeah. I think that she knew what he was doing. She knew that he was meandering. I think she knew everything. Abelis couldn't agree with you more. Plus, I love my freedom and being alone is best. Amen. Allegedly, Jen was always so worried about him becoming a suspect. Yep. Did everything she could to keep him from being a suspect. Jenny said, any and all statements or evidence found before the subpoena can possibly be thrown out if the motion is granted. After the subpoena for Google, I don't see it changing, in my opinion. Yep. And I hope that it's not thrown out. Hey, Sandra, I'm going to read 3 more comments real quick. Well, we can't. Rachel said, well, we can be glad that even if the judge does grant this, I don't think they will. There's lots of evidence on the hard drive in Google that they got a warrant for. They did, but does it show Maddie? Anders said the defense attorney in Idaho 4 is trying to get the DNA evidence thrown out. That's interesting. Titanium IM, thank you for being here, said, I want to know how Stephan Stearns was doing an iOS update on an Android phone. iOS updates for an Apple product. I didn't know that. And thank you for sharing and bringing that to our attention. He said iOS. Yeah. And it's for Android. It would be a system update. So again, that would make me think that Jen told him to do it because she has Apple. So therefore she would say, do an iOS update or whatever. Say it was an iOS update. And he just repeated what she told him to say, which would be an iOS update because for her phone, it was an iOS update. Freudian slip. Maybe. Ultimately, says Lemon Lime, the phone could get thrown out, but they have video of him moving her body into the trunk. So he is done on the homicide case. But what about the CSAM? Real quick, lastly, Cara said, see, I don't think this motion will get granted. He gave them permission to look and they found horrible evidence. I think they're allowed to keep it. That's like giving the cops permission to search. I hope so. I hope so.
The one that Madeline considered a sister. Let me know who you think it could be in the comment section below. Also, Stephan gets caught in so many lies, it's ridiculous.
Case number 24-11313. Today's date is February 28th, 2024. The time is 00:16 hours. Speaking with Stephan again. Okay. So, as you guys know, they have, right? They've been
Mostly things like, when are you going to call us? When are you going to come up here and visit? You poopy head, get on.
So I cut out a name of somebody or something, but she said, you know, they have your phone and they've been going through it. And she talks about what's on his phone. Hey, Free Gaza. Good to see you. Sweetheart, you're not late. You got here right when you were supposed to be here. Anders said I scheduled the updates on my Android. I think mine, I have a Samsung S24 and it'll say, your phone is doing a factory update or whatever. The updates now, I've never had to factory reset it. Rachel said him handing her the phone is permission in my book. I hope so. Is it permission in a court of law?
Online, things like that.
okay. Sorry, I don't mean to cut you off. Your phone. I told you that I was gonna hold on to it and that we would like to download your phone, right?
Okay.
Is this something that I have your consent to do, or do I need to get a search warrant for your phone?
It should be fine.
You're okay with us going through your phone?
Yeah.
Okay. Can I have the PIN to your phone?
So I'm going to play that again because it's important. She asked after. So, okay, wait a minute. Hold on. I need to see when this other interview happened. So we're going to just play the very beginning of this one so I can write down the time real quick.
This is an interview with Stephan. The police pick up on his lies pretty quickly, and they ask him for his phone.
Case number 24-11313. Today's date is February 27, 2024. The time is 19:16 hours. We're in Kissimmee speaking with Stephan Sturz.
Okay. So this was at 19:16
Okay, so we just,
hours.
I know that you're.
And then the beginning of this next one is going to be the 28th at like 1:30 in the morning. What is 19:16 hours? What is 19:16 hours in regular time?
In this audio, we're going to hear several
7:16.
things of importance.
Okay, so that happened around probably around 7:30-ish is when she takes the phone. And then this one where she actually asked him and says that I can, thank you guys. I see it. I'm sorry. I've got to study military time and learn it. Thank you guys. I appreciate that. So I would say maybe about, I think it was like 41 minutes in. So would have been almost 8 o'clock. Almost 8 p.m. when they took the phone initially. And then this happened in the early morning hours. So let's see how much time has elapsed.
Section below. Also, Stephan gets caught in so many lies, it's ridiculous.
Case number 24-11313. Today's date is February 28th, 2024. The time is 00:16 hours. Speaking with Stephan again.
So 00:16 hours would be what, like 12:16 a.m.? Let's see. Yeah, 12:16 a.m. So they had it for 4 hours and 16 minutes without having permission. Well, before asking for permission to go all the way through his phone and stating that we can get a search warrant if you say that we can't. And I'm going to assume that 4 hours is when they were sitting in the car and talking, and the police detective references you sat in him with a car. You sat with him in the car for 4 hours and y'all didn't discuss anything. That makes sense because during this time period, they're at the house. They were at the house when they talked to him then, and then they haven't left. at the beginning of this interview. They're there the whole time, and there's a 4 hour and 16-minute lapse in time. So again, that really makes me think that's when they were sitting in the car talking while the cops were searching. So I'm going to play this again, and we're going to listen to, because while we can agree that we think that he gave them gave them permission to search his phone, and she did everything the right way, what's going to hold up in a court of law is going to be the issue. Hey, Indie Girl. Misty Mo said that verbal acknowledgement worries me because she specifically said earlier, I took your phone. Yep. You can do an iOS update on an Apple Watch, I think. Hey, Allison. Yeah, but I don't think Stephan has any Apple products. And he said an iOS update, which makes me think that somebody said, tell them you did an iOS update. And the person who has Apple devices who would do an iOS update would be Jen. And if you're trying to come up with a story, you're not going to look into little details about, well, I have an Apple phone and it's called iOS. What is it called on a Android phone, which would be a system update? That makes me again think that it's it was very scripted, and that Jen told him to say that, because you don't do iOS updates on Apple products, and most Android users and Apple users don't switch between the two. When I got my phone, I think it was right before Christmas, I got this phone, and they were like, do you like iPhone? Do you want to switch? And I was like, no, like most people who do Android don't. So okay, so Allison said he had his Apple Watch on during the crime. So then maybe that's a legitimate reason for him saying iOS. Thank you, Allison. I appreciate that. Lena Lee said Stephan might have wanted to update Maddie's phone and he wasn't familiar with iOS. That's a possibility. Hey, Gray Man.
Okay. So, as you guys know, they have, right?
Mm-hmm. Mostly things like, when are you going to call us? When are you going to come up here and visit? You poopy head, get online, things like that.
Okay. Sorry, I don't mean to cut you off. Your phone. I told you that I was gonna hold on to it, and that we would like to download your phone, right?
Okay.
Is this something that I have your consent to do, or do I need to get a search warrant for your phone?
It should be fine.
You're okay with us going through your phone?
Yeah.
Okay. Can I have the PIN to your phone?
42586.
Four 2586.
So, sorry, it's loud. I was coming here to get some coffee and my dehydrator's going. Lost my train of thought. So, her saying, do I have your permission to do this, or do I need to get a search warrant, is not giving the suspect or the person whose phone you have the option to say no. They feel obligated to say yes, because you're basically demanding their phone and saying, you can either give me verbal permission or I can get a search warrant and do it anyway. So put in a situation like that, of course the person's going to say, well, yeah, because obviously they feel like they have no other choice. That's the issue. Hey, Blue Giraffes, good to see you. Okay, so I'm going to play just a second of this while I get the documents ready real quick.
Okay. Perfect. Thank you so much. And then, okay, so when you guys FaceTime, what do you guys talk about?
There too, we're just chatting.
Okay. I noticed that at some of the times that you guys are FaceTiming, it's like really late. Is it normal for her to be in bed late?
Yeah.
Okay.
And her bedtime's usually around 10:30, 11 o'clock. I talk to them both before bedtime when I'm not here.
Okay.
10:30 is supposed to be her bedtime, but she gets to push it sometimes.
Okay.
This has always been weird to me. Who is he talking to late at night? And he says, I talked to them both. Hey, poopy head, what are you doing? Like, is he referencing talking to Jen at night and then he talks to Maddie? Or is he referencing talking to another child at night? It's always been weird to me. Hey, Smoky Mountain Mermaid. Hey, Carolina.
When you guys are FaceTiming.
Caroline.
Sometimes phone to FaceTime with her. Sometimes FaceTiming them both together on one of the phones.
Okay. And then you said that yesterday you accidentally factory reset your phone, correct?
Yeah.
Okay. Do you remember what time that was?
No, it was sometime in the morning. I've been pushing off doing an update for a while.
Was that before or after you went to the smoke shop?
Before? I'm not sure. I'm not a morning person. It's a newer.
Okay, so we might come back to that and listen to it again. I'm going to get these documents pulled up while that's doing that. I had to get myself situated. Let me see what y'all are saying. Okay. Caroline said if he said no, they'd have gotten a search warrant and the outcome would have been the same. Well, was a constitutional right violated is the question. Rachel said, well, it really is that way. They can get permission or wait for a warrant. Yeah. Jen and Maddie. Okay. I hope that's who it is and it wasn't another child. Thank you, Jenny Jen. Cara said, hold on a minute. At this point, they had Maddie's phone. I wonder if they had an idea that he had photos on his phone, or was he already on a watch list? So would that fall under probable cause? Good question. I think they just think it's suspicious because he didn't have his phone with him at all that morning. And he's saying that he left his phone at home on the morning that she's gone missing. Indie Girl said, but if he wasn't logged on to Google, why would it have mattered if she asked him or was asking about the warrant? Well, it all boils down to that they got this warrant. Hold on. Well, yeah, let me grab this and read it to you. So I'm going to get this first one. I think it is. I've got 3 documents on here. So I'm going to find the right one. I've got certain parts, well, pretty much all of it highlighted, but that's unlawful searches. The motion to suppress the evidence from the phone is what we're going to look for. Titanium, real quick, said Maddie being missing and him being the last one with her is probable cause, in my opinion. And I think that's what they're basing the search of his phone on. And then the fact that he did a factory reset and they find it suspicious. All right, I've got this document. We got several to talk about, but I know not everybody's down for document reads, but we're going to have to read like pretty much all of this one. And talk about it. Carr said, I wonder if he sent pictures to Maddie, maybe questionable pictures that made them have probable cause to check. Yeah, I don't know. I think, again, the factory reset and at that point earlier in that interview, they were talking about how his path of travel did not make sense that morning. So that's part of it. Like he was being really suspicious. And I think that's probable cause. I think that is the probable cause. Let me give Inspector BS a rest so y'all can see the entire document. If you want these documents without the watermarks, they are in my Patreon. I put all 4 of their most recent document drops in there, along with like a lot of the complete homicide indictment. There's so many documents in there. Veronica said, watching that video a little while ago made me think of how did they sleep while they were renting that apartment by themselves? That's a good question. Jenny Jen said, I believe Maddie's phone was taken in later the day, February 27th. Remember, we watched in the early hours and Jen was showing the officer her text messages. Yes. So they wouldn't have had Maddie's phone at that point. Good point. I'm going to read a couple of comments and then we'll talk about this document. Gray Moon said, in my opinion, detectives have probable cause. He was the last person to see Maddie to search without a warrant. And I think it doesn't violate Stephen's 4th Amendment. They're going to kind of talk about it in some of these documents. Caroline said a child was missing. They had camera footage of him throwing things away and him in the car with her. They didn't know she was deceased for sure, probable cause. I don't know if they had that camera footage at this point. Hold on just a second. Hey, Sue Joy. All right. So this is titled A Motion to Suppress Evidence Obtained from Google Search. And it reads, comes now the defendant, Stephan Stearns, by and through his undersigned counsel, pursuant to the Fourth Amendment of the United States Constitution, Article 1, Section 12 of the Florida Constitution and Florida Rule of Criminal Procedure, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from the execution of the search warrant for his Google account dated February 28, 2024, and all fruits thereof. As grounds for this motion, the defendant states, and then we'll start going through what I have highlighted. So I'm going to try to show y'all everything I have highlighted. I'm going to try to highlight it here so y'all know where we're at. Okay, right now I have all that highlighted. And it reads, the warrant application relied entirely on evidence obtained through prior unconstitutional searches of the defendant's phone, beginning with law enforcement exceeding the scope of limited consent, followed by an unauthorized seizure and culminating in a coerced midnight download. Rather than establish probable cause through lawful means, detectives relied entirely on evidence obtained through these unconstitutional searches to search the Google warrant. This warrant application, built solely on the fruits of constitutional violations and lacking any independent source of probable cause, exemplifies the very type of illegal evidence laundering that exclusionary role was designed to prevent. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search and seizure of Mr. Stearns' phone. Now we're going to see all the reasons that they have that they're stating for this evidence to be suppressed. It says evidence to be suppressed. The defendant moves to suppress the following evidence obtained directly and derivatively from the unlawful search of the Google account. Hold on a minute. All I need is Jesus said they didn't even have his PIN number. He gave it to them. They couldn't look till after he gave PIN and permission. That's a good point. Hopefully it stands up in court. Oh my goodness. Okay. So, pursuant to warrant dated February 28, 2024, I'm going to read all these numbers. They give out so many reasons. Okay, Anna, good to see you, says, by no means am I a lawyer, but in my opinion, the bottom line is he had pics of illegal things on his phone, period. Right, but did they obtain that illegally? It reads, 1, all files, photographs, and videos and media contained on Google Drive folders, including but not limited to over 1,700 files of alleged contraband media spanning from 2019 to 2024, associated metadata, location data, and file creation and modification dates for these files, private messaging data and communication records, cloud storage backup data, and location history and associated information. All subscriber records, internet protocol, IP logs, location data, and account information obtained from Google in response to the warrant, including but not limited to account creation data, IP address logs, and connection records. That's his Google search history, all that. Device identifiers and associated hardware information, account passwords, security information and recovery data, and user profile and account settings data. Cara said, exactly. That's like giving someone your credit card number, expiration date, and CVC code, and then getting mad they used your credit card. Yeah. Yeah. That's exactly what I said. All they could do was hold the phone until he gave him the PIN. That's consent. Hopefully. Number 3, all fruits of the unlawful Google warrant, including physical evidence seized during subsequent searches based on the Google data, witness statements, and investigative leads derived from the Google records, law enforcement reports, analysis, and investigative materials that incorporate or rely upon the Google data, expert analysis reports, or testimony based on examination of the Google records. And number 4, oh, sorry. I apologize. And number 4 is all testimonial evidence and witness statements referencing or incorporating information attained from Google account records. Now we're going to go down here. I have this highlighted. This principle has been consistently reaffirmed by Florida courts, which have recognized that modern technology facilitates the storage of large quantities of information on small portable devices, and that the emerging trend is to require a warrant to search these devices. This constitutional protection extends to cloud storage accounts and digital communications, which often contain even more private data than physical devices. Here, as the account holder with a proprietary and possessory interest in the password protected data stored in his Google account, Mr. Stearns has standing to challenge these searches. And they're requesting an evidentiary hearing to be had because the court must determine whether the warrant application contains sufficient untainted evidence to support probable cause after 2 levels of execution. Now we're going to scroll forward to the statement of facts, which is important. And again, I'm going to go through, hold on. I'm going to go through and, okay, why is it doing that? Oh, because it was printed out of order, I suppose. Hold on, I got to go back to the beginning. Lord, you have mercy. Yeah, this is the first one. Okay. I don't know why it uploaded like all messed up. If you, I will read through all of these documents in a video that I do after the live. If you want the documents unwatermarked, they are on my Patreon. Let me see what y'all are saying real quick. I hadn't, silly phone. Thank you. You're so sweet. Aw. Jenny Jen said that will happen in March, if I'm not mistaken. The CSAM trial is May 5th through the 22nd, I believe. And then the homicide trials the end of September. All I need is Jesus said he sure didn't think there were pictures still on his phone. His 2 factory resets he thought took care of that. Yep. I wish Juan would do an interview too. I don't see any issue with the verbal consent, but I'm not a lawyer or judge. He may not live to the trial date anyway. Good to see you, Fred Field. I don't want to say it would be nice, but I want him to be held accountable for what he did. And the only thing you have when you're in there is hope, and he has hope that he's going to get out on this. And with all of the things that his lawyer is doing, I mean, there might legitimately be some hope that he might get out. Let me get a sip of my coffee and we'll go ahead and get started on this. So this is the statement of facts. It states, on February 26, 2024, at approximately 2000 hours, Jennifer Soto reported Madeline Soto missing to the Orange County Sheriff's Office. Number 2, on February 27, 2024, Detective Francis Hunt identified inconsistencies in statements provided by Miss Soto and Mr. Stearns. So they already picked up on the 27th that Jen and Stephan were lying. Number 3, Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator for the missing person investigation. Number 4, on February 27th, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, made contact with Mr. Stearns at his residence. Number 5, The detective's interactions with Mr. Stearns were audio recorded and captured on the exchanges between law enforcement and Mr. Stearns, and that's what we just listened to. Number 6, Mr. Stearns' residence is located at the address in Kissimmee. Number 7, during this encounter, Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, quote, "Is it okay if I go through your settings real quick? I just want to see if you're logged onto your Google," unquote. Mr. Stearns responded, quote, "Yeah," unquote, to the specific and limited request. Carr said the same judge on Stearns' case was on the Anthony Todd case, and man, did he give it to Todd. Victims justice. Man, did he give the Todd victims justice. The judge even added sentencing for him for unaliving the family dog. I'm glad about that. I hope that is a good, that he does the same for this trial. Jesus, all I need is Jesus, said his lawyers, throwing spaghetti at the wall to see what sticks. Yes, but they might actually have a case. There's like 4 documents on this. They might actually be able to make this stick. All right. Number 9, despite only receiving consent to check, quote, check if you're logged onto your Google, unquote, the detectives conducted an extensive unauthorized search of Mr. Stearns' cell phone data well beyond the limited scope. Number 10, Mr. Stearns explained that he had recently performed an operating system update, which resulted in an accidental factory reset of his phone, causing him to lose all contacts and information. Now, because my documents are out of order, we got to find number 11 right here. Number 11. The detectives' questioning and statements to Mr. Stearns indicated they had accessed and reviewed other unspecified data within his phone, all beyond the narrow scope of consent given. Number 12, detectives used information from this unauthorized search to confront Mr. Stearns about inconsistencies in his timeline and about his whereabouts on February 26, 2024. Number 13, at the conclusion of the interview, Detective Tangler took possession of Mr. Stearns' phone. Number 14, then Detective Tangler stated, quote, "I'm going to hold on to your phone," unquote, and, quote, "I'll give it back to you when we're done," unquote. At this time, Mr. Stearns expressed concerns about maintaining contact with his father through that phone. Number 16, Detective Tangler dismissed Mr. Stearns' concerns by stating they could call Miss Soto's phone instead. Oh, no. Hold on a minute. We're on number 17. Basil just came in and he wants me to put him on the bed. So let me grab Basil real quick. Hey, baby. Okay. Number 17. Mr. Stearns was given no choice regarding the seizure of his phone, nor was any consent sought. Number 18, law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. Number 19, on February 28, 2024, at approximately 1:30, detectives again made contact with Mr. Stearns. 20, the second contact with Mr. Stearns occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. Now, what I thought was the 4 hours, like what we just spoke about, it appeared that it was 4 hours and 16 minutes later. But the court documents say 9 hours and 30 minutes later, so that would be the accurate timeline. Let me see what y'all are saying. Carolina said, "Judge is the same as Todd's trial. That's so interesting. In no way I'd have been saying from day one his attorneys filed the motions." I'd been saying this. I would have been saying this from day one when his attorneys filed the motions. Judge will deny, then smoke and mirrors. Yep, I hope so. Veronica said he takes, quote, the victim, quote, to school, says he has done it other times, forgot his phone twice. His driving around doesn't match the cameras. Factory resetting his phone. It takes any person to know that he's lying, I would assume. Hey, Mercedes. I don't understand these claims. The female detective did ask him if he would give them access to the phone to his data or if they would need to get a court order. Yeah, the way they said it wasn't providing him basically an option to say no, is basically what they're going after. All right. Number 20 stated that it appeared that the second contact with Mr. Stearns occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. Number 21, during this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" Unquote, with a question mark. 22. Hold on, let me flip my page. I have to print it out because I have a hard time reading it on the computer. The detectives presented Mr. Stearns with an ultimatum. Quote, "Is this something that I have your consent to do, or do I need to get a search warrant for your phone?" Unquote. 23, the detectives pressured Mr. Stearns into providing his phone PIN by referring back to his prior, quote, "consent," unquote. 24, at this point, Mr. Stearns had only ever consented to letting the detectives, quote, "check if you're logged on to Google," unquote, a limited inspection that should have taken mere seconds to complete. The second consent for the forensic download was obtained while the phone was already in police possession without lawful authority. That's the issue. Anna said, "Let this be a lesson to police that during questioning, a search warrant should be obtained so that when they ask people for their phone, they're covered." I hope that this is taken seriously and that they do that from now on. I mean, it's already stated in law that they should have done that. And the fact that she didn't do that could get this case thrown out. Like what? Because if they don't have this evidence, what do they have? I mean, it's everything. They got everything from his phone, including access to the Google Drive with all the other stuff on it. Like, her doing this could basically fuck up the whole case. Sue Joy said, even with sitting in a car for 4 hours together, what was Jen Soda on so insistent on getting him a lawyer? She swore he's not their guy. She knew that early in the game. I think is an excuse. Were they supposed to take him out for coffee first? He could have said no at any time, right, Mercedes? Lena Lee said, wait a minute. He discussed handing his phone over with his father and with Jen before he ever gave police to find that there had been some kind of time between asking him and handing it over? Okay, wait a minute. He discussed handing his phone with his father and with Jen before he ever gave the police to find that there had been some kind of time between asking him and handing it over. I know he talked about his dad gave him a phone, but I'm not really sure. I'm a little confused. Fred said, later, guys, I need to get stuff done, and it does not happen in the computer chair. I hope you have a good day, love. Roxanne, good to see you, said that is just ridiculous. He's on tape saying, yeah, it's okay. How can that be unlawful? Well, because they're saying that it didn't appear he had a choice in the matter. And then lastly, before I get back to it, Carolina said there would have to be, quote, case laws attached to her motion. And so far, I haven't heard any. In my honest opinion, defense is just trying to prolong the inevitable. His motions will be denied, allegedly. There is a lot of case law cited in this. I do skip over that while I'm going over it with you guys on the live because a lot of people don't like to hear that. I can reference the case law if you want, but I will do, like, I'll read the whole document in its entirety after today's live when I make that video and get that out. Okay. So 25, the second consent for the forensic download was obtained while the phone was already in police possession without lawful authority. 26, the detectives did not present Mr. Stearns with a written consent form for the initial phone search, nor for any other subsequent searches conducted on his person or property. 27, the detectives did not advise Mr. Stearns of his right to refuse consent to search his phone. That's important. 28, at approximately 2:40 on February 28, 2024, Mr. Stearns' phone was taken into the Orange County Sheriff's Office Digital Forensics Unit. The phone was subjected to a comprehensive forensic examination using Cellbrite technology. Number 30, the Cellbrite forensic extraction allowed detectives to access and examine not only readily available data, but also deleted content, hidden files, system logs, and other digital artifacts not normally accessible by typical users. 31, the detectives accessed and examined personal data unrelated to the current investigation involving the missing person. That's all true. They were looking for Madeline, who was a missing person, thought it was odd that he left his phone at home, and that Maddie left her phone at home, and that his statements were contradicting as far as his location. Okay. And they got access to the information, the videos, the pictures and all that, and I've got that printed out that we can talk about too, what exactly they accessed. And it wasn't relevant to Madeline being missing. That, again, I mean, we have the CSAM trial for the pictures and videos they found when they did the search of his cell phone, and then we have the homicide trial, 2 separate trials, 2 separate cases, right? So that's really important. That the number 31, the detectives accessed and examined personal data unrelated to the current investigation involving Madeline. 32, based on data obtained from these comprehensive digital searches, the investigation was partially transferred to Kissimmee Police Department due to jurisdictional issues. All right, hold on. Okay, Gray Moon said his suspicious behavior combined with other factors is essentially the probable cause they needed to do an intensive search. Fuck all these motions. I hope so. While probable cause does not automatically mean you don't need a warrant, it does mean that police have enough reason to believe a crime has been committed. I hope that that's enough. There's a lot more evidence in Maddie's sheets, also in her drawings. I don't see the judge throwing that out. All the CSAM images, the judge may limit his phone content, but not completely. I hope so. But this could all have been avoided by making sure you did it the right way to begin with. I recall his father saying, if you have nothing to hide, give them the phone. Jen said the same. Thank you for pointing that out, Lana Lee. But he did have stuff to hide, but the fact that he handed it over, I mean, again, could be used, but he's stating basically he felt that he had no other option, and I could see it being possible. Those are all good reasons to get the warrant. Yep. Which can allow them to make an arrest or conduct a search without a warrant in certain situations where the exception to the warrant requirement apply. Yeah, they talk about that though too in these documents. They reference that the extingent search warrant and things like that, the probable cause for that and all of that, and why that was unlawful. Sue Joy said, with all the detectives there and the seriousness of the situation, can't believe all the detectives didn't follow protocol with the warrants. Yep, and that's what upsets me. All right, now we need to go back because this is number 33. I don't know why they're out of order. I printed them out of order too and had to take them apart and fix it. All right, number 33. Detective Hangler noticed at this point that the Kissimmee Police Department was advised of the findings from the Cellbrite forensic extraction, and Detective Corporal Brandon Illigan and Detective Mark Morris responded to the Central Operations Center. 34. During this invasive search, detectives discovered digital evidence that led them to seek additional warrants. 35. One such warrant was sought for Mr. Stern's Google account, sustanet@gmail.com. 36. Deputy Taylor Heller of the Orange County Sheriff's Office sought the warrant for Mr. Stern's Google account on February 28, 2024, the same date as the Cellbrite extraction. 37. No, not today, Satan. In the affidavit for the search warrant, Deputy Taylor Heller lists his training and experience as follows. And this is in the search warrant. Again, that document, along with all of these, are on my Patreon unwatermarked. He says, your affiant, Taylor Heller, has been is and has been since May 25th, 2018, a duly sworn deputy sheriff for the Orange County Sheriff's Office. Your affiant has a bachelor's degree from the University of Central Florida. I have successfully attended the Florida Basic Law Enforcement Academy, completed the Orange County Sheriff's Office Basic Recruit Training, and completed the Orange County Sheriff's Office Field Training and Evaluation Program. I'm currently assigned to the Sex Crimes Unit and have investigated numerous adult and juvenile sex crime cases, completed child sex crimes training. I have investigated numerous internet crimes against children cases training, and continuously complete advanced training in the area. Your affiant has authored arrest warrants and made a warrants for the previous mention. Your affiant has authored and executed hundreds of search warrants to include residential vehicle, mobile device, bodily DNA, electronic services, social media, geofencing, historical cell site data, and internet provider. Okay. Sorry. Misty Mo said if they fail to get a conviction on CSAM, I'm super worried about the homicide trial. We need that conviction for aggravating factor for the other. Yes, we do. Absolutely. They did take both phones. I know you're trying to tell me something, and I feel like we're like right there on the cusp of what you're trying to make me understand, but sometimes I just don't get it. And I'm sorry if I'm misunderstanding everything you're trying to tell me. They do have the video of him tossing her backpack, but that was obtained after they did this quote unquote illegal search warrant thing. Chaz said, but he had the pic in the PC at the storage anyway. But was there pictures of Madeline? So maybe they could still get him on the CSAM he had of all the other children and the bestiality and all of that. But I don't think there was any of Maddie on there. Cara said, in my opinion, he was on a watch list already, and that's another reason they asked for his phone. If he had 35,000 photos of CSAM, he was on a watch list. Yeah, I might have that number wrong. I think it was 3,500, but I swear it was 37,000, but I could be wrong. Caroline said, the law is an ass if it in any way lets a child offender off when explicit material proves guilt for any reason. I agree. It's just what holds up in a court of law. I'm going to read two more and I'll get back to the document. Orange Rose said, this makes me nervous. Maddie deserves justice and there's not an excuse for the police not doing their jobs properly. Exactly. Mercedes said, all these motions sound like they were created by his coddling, enabling mother. Quote, the mean police kept my precious boy up past his bedtime, so his judgment was off. I don't disagree. I don't disagree at all. Number 38. In the affidavit for search warrant, Deputy Taylor Heller referenced the existence of child sexual abuse material, or CSAM, on Stephan Stern's phone through a conclusory statement devoid of specifics as shown below. While investigation, it was discovered, what's redacted, I would assume would be Madeline had been abused. Stephan Stearns had several files of child sexual abuse material involving Madeline on his cell phone, and the images were stored and backed up to his Google account, sustenance@gmail.com. Now I gotta find the next part. Okay, don't be stupid. It's not that one. It's this one. Okay, dokie, sorry, okay. Maybe. Let me see. Okay, yeah. So again, that reads, while investigation, it was discovered Madeline was abused. Stephan Stearns had several files of child sex abuse material involving Madeline on his cell phone, and the images were stored and backed up to his Google account, sustenance@gmail.com. 39 says the affidavit lacks any specificity regarding the purported child sexual abuse material, with no mention of file formats, content descriptions, hash values, or other forensic identifiers. 40. Beyond this one sentence, Deputy Heller's affidavit includes approximately 6 pages of generic, standardized language describing Google services and data storage capabilities, which appears to be a verbatim template with minimal customization to the specific investigation. 41. The Google warrant execution revealed over 1,700 files on a Google Drive folder. 43. These files included photographs, videos, and other media files that formed the basis of the instant case. 44. The files contained associated location data and metadata spanning from 2019 to 2024. 45. All evidence collected in this case, including the Google warrants, resulted in subsequent police investigations. Stearns directly from the detective's initial illegal search of Mr. Stearns' phone on February 27, 2024. Now we have the legal argument. A. All evidence obtained through the Google warrant must be suppressed as fruit of the poisonous tree. The evidence obtained through the Google warrant is the culmination of a series of deliberate constitutional violations by law enforcement, each of which has been separately challenged in concurrently filed motions to suppress. Detectives exceeded the scope of Mr. Stearns' initial consent, retained his phone without proper authorization, and conducted a coerced midnight download. They didn't use the sensitive information extracted from that unconstitutional search, including photos suggesting potential sexual activity, to support their application for the Google warrant. The state cannot justify this warrant under any attenuation or independent source doctrine, as the warrant was built entirely on tainted evidence derived from intentional misconduct. Okay, and then we're at 1. The Google warrant relied entirely on illegally obtained evidence. The affidavit for the Google warrant explicitly references photos obtained during the midnight phone download, describing them as, quote, several files of child sexual abuse material, unquote. The photos, as the direct fruits of an unconstitutional search and seizure, epitomize the, quote, fruit of the poisonous tree, quote, doctrine articulated in Wong Sun versus United States. Let me see what y'all are. Oh, hold on just a minute. Okay. Mercedes said, Strategic did a deep dive on Vickers. I really do think she's a decent person on the surface. It looks like she's defending him, but most of it won't fly, and he won't be able to appeal death. Let's hope not. Maddie, not then found, therefore urgent. Yeah. Kara said Strategic did say on one of his streams that his defense lawyers do this all the time in New York and it never works. So fingers crossed. Let's hope so. If you want fruit of the poisonous tree, explain, just ask. All right. Thank you, Content Angel. Oh, well, thank you, Robin. Thank you for being here. MB said to me, it sounds as if the lawyer wants police to obtain a warrant before they even suspect a crime. Like how? Good point. Hey, YouTube. Good to see you. Wondering if they're setting up for a federal appeals case. Possibly. I think they're definitely going to seek a federal appeals case. So, sorry, let me get back to this. We're at right here. This warrants probable cause. This material gathered through an unconstitutional search and seizure formed the primary basis for this warrant's probable cause. The detectives made no effort to establish an independent source of information or demonstrate any untainted bias for their warrant application. Instead, they relied solely on evidence they had unlawfully extracted from Mr. Stearns' phone, a direct violation of the principles set forth in Wong Sun. Additionally, the warrant affidavit failed to disclose the circumstances under which law enforcement obtained possession of Mr. Stern's cell phone. When a warrant is built on the fruits of unconstitutional conduct, suppression of the evidence obtained through the warrant is mandatory to deter law enforcement from benefiting from their violations and to uphold the fundamental protections of the Fourth Amendment. So basically, again, they're saying it's unconstitutional and it needs to be thrown out because of that. Now I've got over here highlighted. Okay. I highlighted this through the rest of the page. The timing demonstrates an unbroken chain of events where the unlawfully obtained data from the phone was immediately leveraged to craft the warrant application. This chain exemplifies the fruit of the poisonous tree, as there is no attenuation or independent corroboration to purge the taint of the initial illegality. Critically, even after Orange County Sheriff's Office notified Kissimmee Police Department about their jurisdictional over portions of the investigation, Orange County detectives proceeded to obtain the Google warrant themselves based solely on the tainted evidence without allowing the Kissimmee Police Department to conduct any independent investigation. The fact that Orange County maintained control over pursuing the warrant rather than transferring the aspect to the Kissimmee Police Department further demonstrates the complete absence of any attenuation or intervening circumstance that could have purged the taint of the initial constitutional violations. There were no intervening circumstances to break the chain of illegality. The warrant relied exclusively on information obtained from the unconstitutional search. Before we continue on, let's talk about what evidence was obtained from the unconstitutional search and what evidence might be thrown out if this is granted. Let me get my documents in order. I want to give you a warning because this is going to be hard to hear. Let me pull this one up. So this is going to talk about the warrant that they obtained through this supposed illegal search and what could absolutely be thrown out. What could be thrown out. Caroline said the defense knows they are merely making money from the public, may I add. Yep. This is going to be hard to hear. So I'm putting this trigger warning up. I'm giving you your trigger warning right now. Let me get a sip of my coffee. All right. So, what was obtained through this illegal search, supposedly? So, I have... Oh, I can't highlight it. We're going to start right here at While Orange County was serving a search warrant on the premises, a subsequent search warrant was executed on Stephan's cellular phone. Upon reviewing the contents of Stephan's phone, it was discovered several images were saved on a Google Drive. A separate search warrant was served to Google, and upon the receipt of the contents of Stephan's Google Drive, several images and videos were located which depicted an apparent child with her breast, front butt, and back butt opening as the focal point of the pictures or videos. There were also pictures and videos depicting an apparent child's front butt and mouth being penetrated by a member. The child was later identified as Madeline. So that would be thrown out. All of that. I have this one highlighted from Based right here. Based upon the contents of Stephan's Google Drive and the suspicious nature of Madeline going missing, it was decided that I become lead investigator from the Kissimmee Police Department. I have right here highlighted. I was shown the contents of Stephan's Google Drive, where one folder that appeared dedicated to Madeline contained over 1,700 files. A majority of these photographs and videos showed Madeline in different sexual positions. Based upon these images, Orange County detectives began to author an arrest warrant for Stephan. That's going to be really, really bad. That's going to be really, really bad. right there. I mean, that could be the nail in the coffin. Based upon these images, Orange County detectives began to author an arrest warrant for Stephan. Oh, arrest warrant. I thought it said search warrant. I'm sorry. I misinterpreted it, but it's still, I mean, it's still bad. Hey, Paula Jones. Fawny said, we heard her ask and we heard him say, sure. Then later he lawyered up. He knew he was saying yes to the phone. Yeah. Please, I do want to highlight this real quick because I can't scroll up and it's going to be hard to see the bottom. But if this becomes too much for anyone, feel free to exit the video and come back a little later because this is going to be hard. I'm going to be reading some pretty graphic things. So based upon these images, Orange County detectives began to author an arrest warrant for Stephan due to the fact that most of these images appear to have occurred at the residence of Madeline and where they lived. Probable cause was provided to Detective Moore of the Kissimmee Police Department. Detective Moore wrote the arrest warrant charging Stephan with sexual battery and possession of child pornography. Excuse me. Okay. These are all out of order. Oh, nope. Okay, this is the next one I have. That's about as much as I can highlight it. I've got pretty much the whole page highlighted, so I'm going to read the whole page. Jen stated if she needed a good night's sleep due to her anxiety, she would ask them to sleep in a different bedroom. Orange County detectives had previously shown Jen photographs of Stephan's member for identification purposes. Jen did not want to believe Maddie and Stephan were engaged in sexual activity. Jen asked to see the image of Stephan and Maddie. I pulled out a printed picture from Stephan's Google Drive that showed Maddie with Stephan's member in her mouth. Jen said she didn't recognize anything in the picture as if she was in denial. However, she became visibly upset. I asked Jen additional questions unrelated to this particular case. I excused myself and told her I was going to speak with Stephan. I contacted Stephan in an interview room at the sheriff's office. Stephan was asleep when I entered the room along with Corporal Illigan. After introducing ourselves, I explained the reason we were speaking with him. I read Stephan his Miranda warnings, which he waived and agreed to speak with us. Stephan stated he had known Jen for several years and they dated for most of that time. I asked Stephan what the sleeping arrangements were within the home. Stephan stated, Maddie typically sleeps with Jennifer in Jennifer's bed. Stephan stated Maddie wanted them all to sleep in the same bed when he returned from being away for several months. Stephan stated Maddie always needed human contact when going to sleep. Stephan referred to it as, quote, snuggling, which is horrible. Let me see what y'all are saying. They might just be doing everyone a favor. If we could end up with Maddie's law, that would be good. Hey, Wolf. Make a deal with him if he gives up Jen. I want Jen. It would be nice. Okay, continuing on. Stephan referred to it as snuggling. We're right here. As the interview went on, I asked Stephan if Madeline has ever been sexually active with anyone in the past. Stephan stated there was an incident when she was much younger. Stephan stated Madeline did something with a phone or camera, but she wasn't scolded for it. Stephan said she was very young when this happened. I asked Stephan if he provided Orange County deputies consent to search through his phone, and he stated yes. Let me read that one more time. Right here. I asked Stephan if he provided Orange County deputies consent to search through his phone, and he stated yes. I asked Stephan if he had a Google account, and he stated he did. When I asked Stephan if he saved pictures on that account, he said sometimes. Stephan stated he did have pictures of him and Madeline saved to that account. When I asked Stephan about all the pictures he had saved, Stephan then asked if he should be talking to a lawyer. Shortly after that, Stephan requested an attorney. Stephan was arrested for sexual battery from the familial or custodial authority when the victim was under 12 years old and possession of child pornography. A search warrant was obtained to collect DNA from Stephan. The warrant was executed by Orange County Detectives Forensics Unit. I was able to search through Stephan's Google account and observed the following videos and images. Y'all, I'm not even going to front. I'm about to stand by this door right here and open it up and smoke a cigarette because I can't read through this without getting all emotional. So I'm about to read you these file depictions. It's going to be hard to hear. I'm giving you a trigger warning. I can't do it. It's hard to listen to. So I'm just warning you now. These are the files that we will not have access to if they say that his rights were violated. Okay. The first look. Video file depicting a prepubescent female resembling Maddie, who would have been 8 years and 4 months old. Maddie is laying next to Stephan in bed watching cartoons on television. Stephan is asking Maddie to put his member in her mouth for 3 seconds as he counts. Stephan states Maddie would not be able to play with his phone unless she did it. That's the hardest one for me to hear. So we won't be able to talk about that in court. They won't be able to bring that up. Hold on, I gotta find. Okay. The second one is Maddie, approximately 11 years old. Stephan is inserting his finger into her front butt while she appears to be sleeping. The next one depicts Maddie at approximately 11 years old and 5 months old. Stephan is inserting his member into Madeline's mouth while she appears to be sleeping. Like, all of this will be thrown out. And then what case do we have? Okay, because all of this was obtained through Google. All of this was obtained through the search warrant that he says is no longer valid. That the court's trying to say is no longer valid, his attorney. Another one depicts the same thing, member in mouth while she appears to be sleeping. Another one is her 11 years old, putting his member in her mouth while she's under a blanket. Another one depicting her 11 years old. He's putting his member in her front butt, and one of them, I'm assuming because it's redacted, Madeline's identity is confirmed by a mole, one of the moles on her face. The same mark is seen in several other photographs of Maddie. Putting his member into her butt. The next one is 11 years. He's putting his member in her mouth while she appears to be sleeping. The last one on this page is Stephan's putting his member into her butt, and her identity is confirmed by the mole on her face. All of this will be thrown out. If all of this is thrown out, what do we have as far as evidence for the CSAM? Like, keep in mind, this is the CSAM trial, not the homicide trial. If all of this is thrown out, we have no case for the CSAM. File depicting Madeline, approximately 11 years and 5 months old, putting his member into her front butt. Her identity is confirmed by the mole. There were hundreds of other images containing Madeline with Stephan's Google account, which most of them depicting sexual activity. A copy of Stephan's Google account was submitted into evidence. So if they say that they obtained all that information illegally, what do we have? What do we have for this case, for the CSAM? How do we get justice for Maddie? Y'all, I'm pissed. I'm scared. I'm worried. Angie, thank you for being here. He is disgusting. Gray Moon said, rest in peace, Maddie. Your years of suffering were not in vain. We will get justice for you. I hope so. Paula Jones said, wow, I'm afraid a cigarette ain't strong enough for this. My stomach is rolling. It's hard to listen to, but that's the evidence that we need to be admitted into court if we're going to get him convicted for the CSAM. I mean, he horrifically abused this child for all these years. All of that, plus what, 1,700 more? All of that would be inadmissible. Here's the actual arrest warrant, and it states that right here that the judge signed it in and for Osceola County, Florida, 9th Judicial Circuit Court, wherein it is alleged that on or between March 20th, 2022 to December 3rd, 2023, and present in Osceola County, Florida, the defendant, Stephan Michael Stearns, did in violation of the Florida state statutes and commit the offenses of sexual battery in the familial or custodial authority, and possession of material of sexual performance of a child. Now, that was obtained, the search warrant was obtained based on evidence of his Google Drive, his Google account, all of the things they pulled from his Google account, right? That's what they based the arrest warrant on. We just read that in the other document. So if that's thrown out, I mean, the whole entire arrest warrant would be null and void, because it would be throwing out all the Google evidence, all the pictures, photos, and everything he did to this poor child. All of that would get thrown out. And then everything that happened afterwards would be thrown out as it pertains to the CSAM trial. He would still be on trial for the homicide, because that was obtained. They found out he did the homicide through the videos of him driving down the road and all of those other things. You can say that you figured that out in a different way other than searching through his Google account. But if the Google account's thrown out, there was no reason to arrest him at this point. His rights have been violated. I'm really upset. Like, I'm really stressed out. Oh, Lordy, what did you do? Hold on a minute. I was trying to highlight y'all's comment, and then my computer went crazy. Bazard, good to see you. Hunter's Moon, good to see you. I think there's more on CSAM than to prove the latter. Veronica said, and Jen is like, I can't tell what you are showing me in this pic. I don't see it. Can you show me more pics? More? Yeah. It's really, I'm really upset. Matilda said, didn't the hard drive that Dad gave have images? Yes, they did, but I don't know if they had images of Maddie. Okay, so this is the second part of the arrest warrant, and I'm going to read from right here. Who makes this? Okay, the Kissimmee Police Department made this affidavit and states under oath that the affiant has probable cause to believe that certain laws have been violated in Osceola County, Florida, and that on or between March 20th of 2022 to December 3rd of 2023, the defendant, Stephan Michael Stearns, to violate Florida statutes and commit the offense of sexual battery from the familial or custodial authority and possession of material sexual performance by a child. The possession of material sexual performance by a child could be proven by the hard drive that his dad gave, but not sexual battery from the familial custodial authority, because that came from his Google Drive. She is just as disgusting, isn't she? Veronica said, at some point, Jen gets frustrated, saying she really doesn't know where Maddie is and that she would take a lie detector test. And I truly wanted them to say, really, okay, let me set that up in a few minutes. Me too. That would have been nice. Brenda said, sickening that this pathetic parasite crawling all over this innocent little child just sickens me. Yep. Carolina said, I must be missing something, because according to Florida's CSAM law, with a minor under 12 years old, there's no way that the judge is going to throw this out. That would mean that they would have to I was see what else you have to say. If the judge throws this out, let me reiterate. If the judge says that this has to be thrown out, then we'd have no basis for the CSAM trial, but he has not said that this has to be thrown out. I saw that. Thank you, Hio. I kind of saw what you were saying, so I wasn't going to. I appreciate it. Hey, Katya. Thank you for being here. Okay, continuing on. I'm right here. At approximately February 26, 2024, at approximately 2000 hours, a 13-year-old victim was reported missing by her mother. And then I go down here. During the interview with Stephan Stearns, he provided consent to search his phone. But did he? I mean, we heard the interview. Did he? Like, he provided consent, but was it under duress? I should say. Dollyhood, thank you for being here, says he consented review of his settings. I think that green lights for probable cause to research the rest. A good prosecutor can work it out. Lord, I hope so. I really hope so, because I'm real upset. Like I'm feeling some kind of emotional right now, y'all. Okay. Continuing on. Let me read this bottom part again. I am right after 8:10 right here. I start right here and then read through the bottom. During the interview with Stephan, he provided consent to search his phone. However, he stated he accidentally performed a factory reset on his phone on February 26, 2024. The same day the victim went missing, Stephan provided his phone number to be, and it gives that. Now we're going to go back to this document. That one. That's what I have next. And I'm reading. Nope. That's not it. Hold on. Let me find the right one. Because my documents are all out of order. Okay, that's the beginning. Right there. Okay. And I'm reading from right here all the way down. Upon reviewing the contents of Stephan's phone, several images and videos were located which depicted the missing juvenile with her breast, front butt, and back butt opening as the focal point of the pictures and videos. There was also pictures and videos depicting the missing juvenile's front butt and mouth being penetrated by a member. As such, the files depict sexual performance of a child. Your affiant has probable cause to believe Stephan was in possession of material depicting the sexual performance of a child. It should be noted that the member observed penetrating the victim had a distinct marking on it, which consisted of bright pinkish colored skin below the head of the member until approximately a quarter of the length down the shaft of the member. Several other pictures capturing this distinct pattern were observed on the phone. Further, as your affiant was reviewing the pictures and videos, I was observing several different pieces of clothing to include patterned underwear, shirts, blankets, and sheets. Simultaneously, detectives of the Orange County Sheriff's Office were executing the search warrant at Stephan's home address. This address is also where the victim and her mother live. The detectives searching the residence were contacted and confirmed that they found the same distinctive clothing both in Stephan's room and the victim's room. Based on the totality of these circumstances, your affiant has probable cause to believe Stephan committed a sexual battery of the familial or custodial authority on the victim. So all of that would be thrown out. And I questioned if he could say his constitutional rights were violated by them doing the search warrant of him and his member and all of that, because in order to do that search warrant, they would have had to have the pictures and all of that from the Google Drive. You understand what I'm saying? Because that's how they knew there was a distinctive mark on his member and all of that. They got that from the search warrant they obtained referencing the Google Drive. And then this is the last part that I have highlighted. Basically, Zach, the defendant, will be testifying and saying he unalived the person, and even though he pleaded not guilty. Oh, you'll have to let me know. Katya has a true channel, True Crime Addict 8, I believe is what it is. I'd have to, maybe Hio has it and can drop her link. She covers court cases as well. Really awesome channel. Definitely check her out. Hey, Dainty Dane. Aw, so sweet. Okay, let me scroll up. Lori said the DA said to Jen, if you told us there is a firearm, we need to find that out ourselves. So assuming they need a warrant to look, right? That's the issue. Basically, like she said, like the DA told Jen in the immunity interview, if you tell us there's a firearm, we would have to prove that we found that out a different way. So if they say the search warrant is illegitimate and you can't do that, then basically we have to say that we found all of the images for the CSAM and all of that a different way. Can they do that? I doubt it. So, and then the last part I have, the last page I have as far as the evidence that would have to be thrown out is this. First part I have highlighted is right here through the rest of this paragraph. During the interview with Stephan, he provided consent to search his phone. However, he stated he accidentally performed a factory reset on his phone on February 26, 2024. The same day the victim went missing. Stephan provided his phone number to be, and then I have from upon review of the contents from this all the way down to the rest of the document. Upon review of the contents of Stephan's phone, several images and videos were located which depicted the missing juvenile with her breast, front door, back door opening as the focal point of the pictures. There were also pictures and videos depicting the missing juvenile. I think I read that. Yeah, we just read that. Okay, I don't want to reread that again because it's already bad enough. Last part says, due to Stephan being the last person seen with the victim, and it is known there was ongoing sexual abuse between the two, your affiant is requesting a search warrant for the above described items. So, hey, smart ass. Fawney said, I think the defense is just trying anything that could help the case. Not that they think it's going to work. It's a shot in the dark. Noodles on the wall. I hope so, but I mean, I'm going to close out of this and play the interview again. I mean, you guys will have to let me know what you think, and then we can go through the CSAM interview. I have that in my playlist, and I mean, that basically breaks down also all the evidence that was found on his phone. We probably need to listen to that. I haven't grabbed any timestamps from it because I didn't have time, but we can review that too real quick. Some parts of it that I can skim through. I mean, all of that evidence will be null and void, basically. So I'm going to replay what we heard at the beginning of the stream, and you guys tell me what you think after hearing all that and what was stated in the documents. Some of the documents. Basil. Stop. Oh, hold on. Hold on. I had started playing it and didn't even have it up. Okay. Hey, Sarah, you're not late. You got here right when you were supposed to be here. So let's listen again and see. I mean, you heard somewhat on the documents. Make sure you check out the video I'm going to get out later today or tomorrow, where I read through all the documents and you can hear their whole entire case. If you want to write the timestamps down, I have 21 and 41 written down on this interview, and then the beginning of the other one we're going to play.
Time around.
Yes, and then make it right down to the school.
Do you
Okay.
remember what time you dropped her off?
I estimated it to be sometime between 8:20, 8:40.
Are you on your phone? Do you have Google Maps?
I do, but I wasn't mapsing it.
When you're giving her rides, does she sit in the front or the back?
She sits in the front.
Carolina said Stephan Stearns not only agreed once but twice, so that proves he wasn't under duress. Also, the way I understood the motions his defense attorney filed, it's not going to hold up. I hope not.
Do you mind if I look at your maps real quick?
Yes.
Thanks.
And just to confirm, also, you said, so the second time around, you said you went up Jongyang Parkway, you went through town center.
So he just gave consent to look at the maps real quick, because she said, again, like they stated in the document, do I have permission to look at your maps real quick? Now let's go to 4055.
December?
And you said the reason was for your parents down there?
Yeah. Going down to help them because they're getting on in age and they're making their end-of-life plans and they need someone to help out.
Can you unlock this one more time?
Sure.
I saw y'all talking earlier about that. I think that, I don't know, the jury might hold some hostilities against it, but if they felt like, I mean, I don't, if that's a legitimate thing that the Stearns were doing, then I don't know if they would find, contentment or resentment in that statement that they were making end-of-life plans. Sue Joy said defense has to prove the time of the warrant versus extraction of the phone. So far, they're making allegations without proof. I'm being glass half full. Hopefully. Her channel is True Crime Addict 8. I'm gonna grab it and drop it real quick. Oh, do y'all want to come up? If y'all want to come up and talk about it, I'll drop the link. I forgot. I forget to drop the link. There you guys go. If you guys want to come up and talk about it. Thank you, Hio. Let me grab my phone and highlight that. I'm going to pin True Crime Addict 8's channel at the top. And then I just dropped the StreamYard link if anybody wants to come up. Hey, Supero. He was making end-of-life plans. Yeah, from what I understand, the parents were making end-of-life plans. Linda Glover, good to see you. These lawyers should lose sleep at night, have nightmares. This is unfair. They know what he did and to who. Yeah, but they're like talking about the notoriety of the case. I'll see if I can find it while we listen to this timestamp real quick. I want you guys to hear what they said. Hey, Bazard, how are you? I don't know if you're talking, but I can't hear you. Oh, now I can. You're cutting in and out. While you get that fixed, I found it. So at the end of the document,
can you hear me, Alleged?
Yeah, I can hear you.
Okay, my internet must be acting up again. But I just want to come on right quick and ask. My question was, now, is what his defense implying that he wasn't served like his Miranda rights when the female detective asked him to check his phone? Is that what they're trying to get at? Because that's my question I was thinking or in my mind.
So basically, and I can read the other document too, but they're saying his constitutional rights were violated because she asked to search for the Google Maps. She didn't ask to do a comprehensive search of his phone. She only asked to look at the Google Maps. So therefore, she didn't have permission to do a comprehensive search of his phone and didn't have permission to find all the files that she found. And then also that because they took the phone, kept it for 9.5 hours without getting a search warrant, and then came back 9.5 hours later and said, do I have permission to look in your phone, or do I need to get a search warrant? And then the way they asked him, like, do I need to get a search warrant? They didn't give him basically the right to object that 9.5 hours is way too long to have the phone without having consent to search it. And that they only asked to go through the Google Maps to begin with. They didn't even ask to search the whole entire phone is the issue.
So basically, just like with the Nevada girl, it's like a technicality kind of bull crap. That's what it sounds like they're trying to do.
Yep. Ugh. And is it going to stick?
Yeah, because like I get it. It's just, I guess as we as laymen, individuals, we kind of hate the idea and perspective that someone who clearly is guilty of something is going to get off over a technicality, or at least a certain aspect of it.
Yeah, if the judge decides that they're right, and they cite several cases and the 4th Amendment, 16th Amendment, all of the things. So if legally they have to throw it out, then we only have the CSAM trial because that's everything we only have the homicide trial because everything they obtained from the Google search would be null and void, and that's everything for the CSAM.
I'm just hoping the judge don't do that. But that was what I was questioning. Like, are they trying to get with the whole, like, they didn't give him his Miranda rights? And then I guess in my mind, I'll be like, well, if I was the prosecution or judge, maybe the judge more, it'd be like, well, didn't your client agreed to let the detective and or investigators have his phone for, maybe a certain amount of time, but he agreed to it. And it's like, are you coming to me now trying to say, well, because they didn't do this and that, we can't use this as evidence? Your client agreed to it because, and I guess if I was the prosecution, it'd be like, because he thought he deleted everything off his phone.
Yeah.
And that'll be like the only, I guess, if I was a prosecutor or judge, that would be my counter to what his defense is saying. Your client believed that he deleted all the stuff off his phone. Did your client or did your client or did he not have child pornography on his phone? And then, I mean, I know his defense would say, well, that doesn't matter. Like, it does. It does.
It does matter, but if they found that information out illegally.
True. Yeah, that's true. That's true.
Hmm.
And then it would be like, yeah, you went against his rights and blah, 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 blah.
Right. So I'm concerned. I don't know.
I'm hoping
know.
that, yeah, I'm hoping they don't. Mhm.
Go ahead, love.
I'm just hoping they don't, the judge just be like, well, he'll find something, or even the prosecution will bring up like, well, he legitimately thought he deleted everything off his phone. And then we find out that, when we were investigating and looking through his phone, we still found this stuff.
Yeah. Yep.
So,
I hope so. I'm going to play this last part where she basically tells him, and y'all can tell me what you think. We'll read through these other documents. I'll go through some of them so we can talk about it.
I have a question.
Yes.
Sorry, are you guys done?
No, okay.
The other detective mentioned that you did not have your phone yesterday.
Correct.
Tell me about that.
I left my phone at home in the morning too. I was so busy riding her to the door on time that I left my phone. She left her phone.
Okay.
We both left our phones.
Did you have your phone when you went to the smoke shop?
Not the first time after I dropped her off. I was still without it. I got my phone and went back to the smoke shop
Okay.
later when I got home.
And then I also noticed, I was checking your call history. I noticed that you.
I wonder if they can use the fact that she said that. Like, obviously she's questioning because the story doesn't add up, and it's suspicious as AF that he left the phone at home the day that she goes missing. So I'm wondering if they could say, well, I mean, we were already going to search anyway because of that. Like, that was the reason for the search of the phone when we found it. I mean, I guess it wouldn't change whether they asked legitimately for the search warrant or not. I don't know. Oh, I lost Bazard. There you are.
I'm here. It's my Wi-Fi. I'm gonna see if I can get out the house and I do need to charge my phone. Maybe I'll just get in my car and drive somewhere because the Wi-Fi in my house is acting up. I don't think they're like doing nothing electricity wise or whatever outside, but something's wrong with my Wi-Fi.
Well, try to reset your router and see if that works.
All right, I could do that. But I was planning to go outside anyway to get in my
Okay.
car and I had to go somewhere. But that's fine. I'll still stay on here, and if it goes out, then I'll just go in my car.
Okay. All right, I'm going to play the real quick. I wanted to read the end of the other document before we start on the other two that I have. The end of this document says, it reads, which I found interesting, the gravity of the underlying investigation and the intense national media attention it has attracted cannot justify the systematic dismantling of constitutional procedures witnessed here. High-profile cases that capture public attention and inflame emotions present present the greatest test of our constitutional principles. The Fourth Amendment's protections against unreasonable searches and seizures cannot be preserved if law enforcement is permitted to exceed the clear scope of limited consent, exploit unauthorized searches to maintain control of private property, use constitutional violations to establish probable cause for broad intrusions, and launder tainted evidence through the warrant process, which I found really interesting. I was like, okay, ma'am. Thank you for writing that so eloquently. Are you telling us that the media attention that you've garnered from this and that this case is garnered is why you're doing all these motions and asking all these questions? Y'all can't have Basil. That's my baby. I would die. I would literally die if he wasn't here with me just for one day. Dollyhood said the cops could say, quote, I was reviewing his settings and the storage indicated pertinent data could be present to help find Maddie. They could. At this point, Hey, Becky P. At this point, go back a little. Okay, I will, Jen. He does say, so busy riding her to the door. Let's see. I'll start it over. Hold on. Not all the way, but I'll go back to 40. Let's listen again.
When's the last time y'all lived together?
December.
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 And you said the reason was for your parents down there?
Yeah, going down to help them because they're getting on in age and they're making their end of life plans and they need someone to help out.
Can you unlock this one more time?
Sure.
I have a question.
Yes.
Sorry, are you guys done?
No, we're good.
The other detective mentioned that you did not have your phone yesterday.
Correct.
Tell me about that.
I left my phone at home in the morning too. I was so busy riding her to the door on time that I left my phone. She left her phone. We both left our phones.
Okay, it's redacted, but what I'm going to assume he said was, I was so busy riding her to school and trying to get out of the door on time that we left our phones. I'll back it up just a little bit. But you got to remember that part's redacted.
I have a question.
Yes.
Sorry, are you guys done?
No, we're good.
The other detective mentioned that you did not have your phone yesterday.
Correct.
Tell me about that.
I left my phone at home in the morning too. I was so busy riding her to
Redacted.
the door on time that I left my phone. She left her phone.
He does say riding her to school. Riding her to school, riding her to Hutter's Creek is what I'm going to assume he said, and getting out the door on time that I left my phone.
We both left our phones.
Did you have your phone when you went to the smoke shop?
Not the first time after I dropped her off. I was still without it. I got my phone and went back to the smoke shop
Okay.
later when I got home.
And then I also noticed, I was checking your call history. I noticed that you don't have anything before this morning. Is that unusual on your phone?
No, it's a new phone. Stupid. I went to do an update yesterday morning, and I don't know what the fuck. Pardon me. I don't know what the heck I did, but somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts, all my information.
Mm-hmm. What time was that? Do you remember?
Oh, sometime while I was hanging out with Jen. Jen might know. I looked at.
So I just thought about something. Real quick, Sandra had said, what are the chances of him and Madeline Soto both left their phones? I'd like to say 0 to none. And I think that is a probable cause enough for them to be asking to search the phone in the first place. But the factory reset was done at like midnight. And Jen is always saying she needs a good night's sleep. She's got to go to bed. They state that Madeline goes to bed usually when they go to bed, which is around 10:30, 11. But they're sitting up talking. And he says sometime while I was hanging out with Jen, and it was done like at midnight that night. So why are they up so late talking that night? I mean, I guess it would have been because Maddie's missing supposedly, but she said she still went to bed like nothing was wrong, slept like a baby. I'm putting that, she didn't say slept like a baby, but it appears she slept like a baby. Sandra said he knew he could be tracked by the phones, but he didn't know they could get info after he factory reset his phone. Yep. And what kind of dumb stuff is that? Operating system update. Yes. Thank you, smart ass patriot. Good question, my love. How is Jen still free? I hate updating my phone personally. All right, we're going to play the end of this, and then I'm going to read this document that is the motion to suppress evidence obtained from the unlawful seizure of the cell phone, and it's basically going to outline how all of this is unlawful, what we're listening to right now.
Pateron said, "What did I just do?"
Okay.
She might know better. I don't know what time it was. It was when I was here with Jen.
Okay. I don't think I have any other questions. Do you,
I
Louis?
don't know where my head was yesterday. It was so far up my backside.
It's okay. We understand. In the meantime, while we're waiting for all this to get sorted out, I am going to hold on to your phone, okay? I'll give it back to you when we're done.
Okay.
Okay? Do you have any questions for us?
How long are you gonna need my phone? That's
I'm not sure. I'm waiting for my supervisor to call me.
my dad. It's just my dad's using that to get a hold of me and get updates.
They can call Jen's phone.
Okay.
Did the other detective give you his business card?
I believe so.
Okay, well, here's mine in case you want it for any reason.
Okay.
Okay?
He didn't have a choice in that. I mean, to be fair, and technically, I mean, it is a technicality that could have messed this whole thing up.
Do you swear that everything you told us is true?
Yes.
Okay, thank you so much. Thanks for your time.
So I'm going to play the first part of the second video again, and then I'm going to read that document to you. And then to get the last one, you have to watch the video that I put out. Because they all like highlight different parts of basically this conversation.
No, it was sometime in the morning. I've been pushing off doing an update for a while.
Was that before or after you went to
Okay, we're going to go back to here and just play this little part.
Also, Stephan gets caught in so many lies, it's ridiculous.
Case number 24-11313. Today's date is...
So Leah said Stephan could have said no. This cop was direct and fast. Yeah, and they're direct and fast for a reason. Like they're trying to get permission through a backhanded way. Like they're trying to be fast and all of that to make you think on your feet, like quick, like hurry up and think, because that's how you trap somebody in a lie, by asking them like real quick, like back to back. You know what I mean? Teresa said, I don't know if live comments help your channel. If so, here you go. I'm not up for this today. Okay, well, thank you, Teresa. I'm sorry. Dolly Hood said, if she hadn't taken his phone, we'd be faulting her for not taking his phone. This cop acted in the best interest of the investigation. I agree. I hope that everything is okay with this.
February 28th, 2024. The time is 00:16 hours. Speaking with Stephan again.
Sandra said, without this evidence, I don't think they could get a guilty verdict. Right. And then that's going to be, we're not going to have the aggravating factor for the homicide trial, which is I mean, it's going to be devastating if this document goes through. Tony said he did let him have it though. Yeah, but to search for Google Maps, not to search everything, but you know, technicalities.
Okay. So, as you guys know, they have...
Oh, I'm
right?
sorry, Mercedes, for whatever happened.
Mostly things like, when are you going to call us? When are you going to come up here and visit? You poopy head, get online, things like that.
Okay. Sorry, I don't mean to cut you off. Your phone. I told you that I was gonna hold on to it, and that we would like to download your phone, right?
Okay.
Is this something that I have your consent to do, or do I need to get a search warrant for your phone?
It should be fine.
You're okay with us going through your phone?
Yeah.
Okay. Can I have the PIN to your phone?
Okay, so y'all got that. Let's talk about this, how the seizure of his cell phone was unlawful. Real quick. Hold on just a minute. Do. Unlawful seizure. Yes. Okay. Again, if you want these documents for yourself and you want them without the watermarks, you can get them on my Patreon. I've got these documents along with the entire homicide indictment, all like, I don't know, it's well over 1,000 pages. Plus a lot of other court documents, a lot of things are on the Patreon if you guys are interested in that. Okay, so this is a motion to suppress evidence obtained from the unlawful seizure of the cell phone. First part I have highlighted is here, the introduction. This case presents a flagrant violation of Mr. Stern's constitutional rights under the Fourth Amendment, Article 1, Section 12 of the Florida Constitution. Detective Tangler with the Orange County Sheriff's Office unilaterally seized Mr. Stern's cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported, quote, consent, unquote, for its forensic examination. Because the seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress all cell phone evidence and all derivative fruits. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stern's phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. Evidence to be suppressed is any and all tangible or intangible evidence obtained contemporaneous to the following. The illegal seizure of Stephan Michael Stern's cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through the execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. So again, all derivative evidence and investigative leads developed through the illegal search of the cell phone. Good Lord, how many leads did they get from the search of the cell phone? You know what I mean? Okay. Sandra said, I have to believe the judge will interpret the law to deny this motion. This evidence is sickening. I hope so. Bad girl, thank you for the trigger warning. All right, let me see what else I have highlighted. Next, we're going to go through another statement of facts. Sorry if that was loud. It was like right by the speaker. I apologize. So, statement of facts. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. On February 27, 2024, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator. Number 4, on February 27, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. Number 5, the detective's interactions with Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns. Mr. Stearns' residence is, Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google. That's the issue, right? Like, I just want to see if you're logged into your Google. Technically, that's all they asked for. That's all that they wanted. That's all that they asked for, was to look at the Google to see if they're logged into the Google. You know how we feel, but it's what can be proven in a court of law. Blue Giraffe said defense acts like the police pistol whipped him and yanked his phone away. He clearly gave consent. Right. I agree. Number 8, Mr. Stearns responded to the specific and limited request. Number 9, after exceeding the scope of this limited consent, Detective Tangler unilaterally announced, I'm going to hold on to your phone and I'll give it back to you when we are done. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. Detective Tangler dismissed Mr. Stearns' concerns by stating that they could call Ms. Soto's phone instead. Mr. Stearns was given no choice regarding the seizure of his phone. No consent was sought for the seizure of the phone. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. Number 15. The detectives did not present Mr. Stearns with a written consent form for the seizure. Do you remember when we went through the video that the person, I can't remember his name, but the person where Maddie's body was found, right? The person who owned the property, he had to fill out a consent for them to go on his property and remove Maddie's body. So he had to fill out that paper, that document that you see in that video. Amos said, did he shake his head? Yes. Motion as he said, I feel like body language also is accepted as consent since he didn't fight or change his mind last minute. That's a good point and a good question. I've asked for body cam footage from that interview and several others, and what I've been told was that when a detective is doing an interview, they don't wear body cams. It's audio recorded, but there's no body cam footage when a detective is doing an interview because they are a detective. So there probably isn't any body cam footage to show whether he like physically shook his head yes or not. But it sounds like it. Oh yeah, the cops suspected him, and is that enough? Like the suspect, the fact that they suspected him, is it enough for them to be able to go around another way and basically prove the whole CSAM trial without all the CSAM evidence? Which probably the answer is probably no. Okay. Number 17, the detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. Number 18, the detectives did not document any exigent circumstances justifying the warrantless seizure. On February 28, 2024, at approximately 1:30, detectives again contacted Mr. Stearns. The second contact occurred approximately 9 hours and 30 minutes after the initial seizure of the phone. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, I told you that I was going to hold on to it and that we would like to download your phone, right? Unquote. The detectives presented Mr. Stearns with an ultimatum. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? 23. At the time of this midnight, hold on. Number 23, at the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. Oh, Lord Jesus. Goodness. I'm going to read that again. Number 23, at the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. Actually, he wasn't detained yet. 24. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. Mr. Stearns had not eaten all day prior to the incident. Oh, God. Lord have mercy. Listen to that. I'm going to read 23, 24, and 25 again. At the time of the midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. Mr. Stearns had not eaten all day prior to the incident. Maybe he didn't eat because he was so stressed out about what he had just did. You know, the whole homicide of a 13-year-old child. Lord have mercy. I wish I had the world's smallest violin to play for him right now. Right? Abella said, oh my God, what? Please. 50 to 60 degree temperatures. Oh my. I wish we could all speak a universal language. You know, they did that in the Bible. That's why the Tower of Babel fell down. Tower of Babel. Blue Giraffe said, oh my, his core temperature must have been near dangerous levels. Right. Poor man, baby. Here's some gummies. So cruel. Right. Regina said, Maddie's more mature than both them rats. I agree 100%. Yep, there you go. There's my violins. Wah, 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 wah. Sandra said, I don't know the issue with law enforcement. I don't know. The issue with law enforcement is they don't know the laws. When my children got their driver's license, they didn't even know Florida law as to what time they could be on the roads. Law enforcement needs more classes in the law. I don't agree. I don't disagree with that. I think we could all use more classes on things. I think parents could all use parenting classes, all of that things. I agree 100%. Number 26. Mr. Stearns was not allowed to return to Miss Soto's vehicle, which was heated despite the cold weather conditions. Earlier that night, Mr. Stearns had taken an Ativan as a prescription medication to manage his panic attacks. 28. Mr. Stearns clarified to the authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. Ativan is known to cause drowsiness, sedation, and impaired alertness. 31. Mr. Stearns describes the effects of Ativan to law enforcement, stating, "This is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours." 32. At approximately 2:40 on February 28, 2024, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. The next thing I have highlighted, I'll read right here, starting right here. This instant matter presents precisely such a meaningful interference as Detective Tangler unilaterally seized and retained Mr. Stearns' cell phone for over 9 hours without consent or probable cause. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with the Fourth Amendment jurisprudence, and they cite State versus Hernandez from 1998. The next thing I have highlighted is the very first paragraph on this page. Hold on, let me get him some crackers. Here, do you want your crackers? Oh, yes, Mama, give me the crackers. Give me the crackers. Here. Well, fine then. All right. Sorry about that. Sorry if it was loud. First paragraph. While law enforcement may temporarily seize property to prevent the destruction of evidence while seeking a warrant, such seizures must be, quote, properly limited in scope, unquote. Place 462 U.S. at 706, the United States Supreme Court has emphasized that courts must consider the length of the detention in determining whether a seizure is reasonable. The Supreme Court held in place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed unreasonable in place. You want some crackers? You want some quackers? Some quackers? Bad Girl said, isn't an incubus supposed to be a demon that, yes. A male succubus would be female, the female form of that. The male is the incubus. Female is succubus. Dollyhood said, I'm interested in how the prosecution will argue this. Technology has very much changed in the way we convict. So it changed the way we seek out evidence. I'm wondering that as well. All right, I've got the last paragraph on this highlighted, and it reads, the extended duration and complete deprivation of Mr. Stearns' possessory interest in his phone demonstrates why this case falls squarely within places holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tangler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Instead, Detective Tangler retained the phone for over 9 hours without providing any indication of whether or how it would be returned, far exceeding any reasonable scope of duration under the Fourth Amendment jurisprudence. The length in detention alone precludes any argument that this was a properly limited investigative detention under Place and its progeny. Next thing I have highlighted. Again, if you want me, like, if I will read the entire document in the videos that I put out later today instead of like skimming through. The very top of this page right here is what I have highlighted. I just highlighted it in blue for you. In the instant case, Mr. Stearns provided extremely limited consent for Detective Tangler to, quote, go in your settings real quick, quote, solely to, quote, see if you're logged onto your Google, unquote. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of the device. Right, but like, when you think you factory reset the phone and hand the phone over thinking that everything has been erased, and then you find out that it hasn't been erased, and now the police have access to all of the abuse. Oh, Bazard, I'm so sorry. I don't know how long you had been there. I'm so sorry.
Oh no, it's just been a minute. I finally got my Wi-Fi working because I'm actually outside. So yeah, there's something going on with my router. So
Okay.
I just left. Yeah, I just left the house.
Okay.
But you can hear me if I have any issues because I have my Bluetooth set headphones on.
No, I think you're good. If I hear it echo, I'll let you know.
Copy that. But yeah, I just caught up to what you were just talking about. Yeah, what I was saying earlier. I don't know how his lawyers think just because he factory reset everything that this is all going to somehow excuse the bullshit that he had on his phone, the stuff that he did to Maddie.
Right. Well, if they can prove that basically getting that evidence at all was unlawful is the issue.
Mm-hmm.
And it's gonna suck if they're able to. I hope to God that the judge doesn't grant this order.
I'm assuming it's a he or she that's going to be for his CSAM trial.
She, the same, I think it's
Okay.
the same attorney in both, Melissa Vickers.
Okay. Yeah, I'm hoping that it doesn't go through because if I was, like, say, a judge and I'm hearing both sides, and I mean, I'll be fair and partial as best I can in this particular case. You know, it's hard, but it still be, well, Mr. Stern's lawyer, whatever, your client thought that he deleted or factory reset everything off his phone. So he seemed to have no care in the world that the authorities were going to look through his phone because he believed that everything was gone. Well,
Right.
Turns out it didn't. So,
Yep.
See, if I was the judge, I would be like, well, it doesn't look like it's going to help you out in this time.
Yep. Hope so.
Mm-hmm.
Mercedes said that was only the first question. The follow-up question clarified their intention with his phone. He agreed both times. I hope that holds up.
Yep.
I hope it holds up.
And he did it so nonchalant, like such an arrogant asshole prick about it. Like, oh yeah, sure, yeah.
Yep.
You can look at it. Mm-hmm.
Everything he did was so nonchalant, the little asshole.
Mm-hmm.
Yep. All right, continue it on. Okay. Let me show y'all where I'm at. Okay. I'm going to start from right here and continue to read this paragraph. Detective Tangler's unilateral announcement that she was going to hold on to your phone and subsequent extended seizure far exceeds any reasonable. I'm going to mute you for a minute because I can hear you driving and stuff. So I'm just going to mute that. And then you unmute when you want to talk.
That's fine.
Okay. 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 Detective Tangler's unilateral announcement that she was going to hold on to the phone and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stern's limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appelt and Wells. Just as consent to look in a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. So what do you guys think when they correlate it to the, like, just like looking in a trunk does not permit searching closed containers? When they correlate it to that, like he gave permission to check this single setting, not look at the whole phone, just like if you give permission to search the trunk, you can't search closed containers. What do you guys think?
I was gonna say, well, one of that analogy be like, okay, you look through the trunk, but then, and let's say in the trunk there's a container, and you smell an odor of a dead body, even though you weren't technically looking for a dead body. Then it'd be
Yeah,
like, okay,
that's a good point.
I'm gonna mute myself right quick because I'm driving.
Oh, you're good. That's a good point. I mean, that's a good point as far as that goes. I can agree with that. Now, obviously, they're not going to smell something from images on the phone. I wonder if there was anything that made them question, like if there was some kind of like maybe they saw some hidden files and therefore searched more deeply into the phone. That's interesting.
So when they start getting more curious when they found one, because okay, when did they start taking the photos of like the house, and they found his fucking, excuse my language, but fucking drawers in Maddie's laundry basket? Because then if I was a detective, I would have been suspicious. Like, why is there a man's underwear in a little girl's laundry basket?
Right. They state that they performed the search of the phone and then subsequently they were searching the residence. So therefore, they asked them to get specific clothing articles related to the pictures in the phone. So it was going on simultaneously, but they were asked to get specific evidence after they saw the pictures on the Google Drive. Hey, Gil.
Okay, so it was like a somewhat time different space when that was going on a little bit.
Mm-hmm.
Well, if like I said, if I was a detective and I started, even say when we started investigating the house and just trying to see, okay, well, let's find her phone or whatever. When they had the dogs, and if I went in there and had her clothes, look for her, then get the dogs to sniff, and then I notice a man's drawers in a little girl's laundry basket, I would be highly suspicious of that immediately.
Yeah. Yeah. I mean, and that would give possibly give probable cause to search the phone, maybe, to search all devices. Maybe they could say that, but in the warrant, it specifically states that it was because of the search of the cell phone that they obtained certain clothing articles and bed sheets. But I do see your point, and maybe it can be relevant and correlate to this. Hopefully, it will.
Yeah, I mean, that's the best thing I can think of. Like, even if they didn't have, let's say, certain things, you can see, like, well, while we're investigating, we noticed that there was a man's underwear in a little girl's laundry basket. We thought that was suspicious or curious, since he seems to be the only male in the household, other than the other roommate's son. So, but it was like a large male size underwear, and he's only the large size male in the household. So,
Yeah. Yep. I agree with that. Yeah. That's a good point. Thank you for pointing that out. Dolly said he was the last person to see her alive. He admitted to sleeping with her the night before. That's us. Yeah.
oh yeah, duh. I had to hit my head on that one. I'm like, duh, yeah. I forgot about. No, I didn't forget about that. But that should have been like an obvious suspicious thing, as anyone knows. If you're the last person to see the missing person or victim alive, you're always going to be, unfortunately, number one suspect, even if you're innocent.
Yeah. Yep. Absolutely. So, I mean, therefore, it would have given them a reason to search his phone and all of the things anyway.
Mm-hmm. Exactly.
So, hopefully, that'll be taken into consideration. Y'all got some good points. Thank y'all for sharing. All right. I'm going to mute you while I read this page. Oh, okay. I was trying to unmute you and then anyway, it was going to unmute you. All right. So I have basically the rest of this page highlighted. So we're going to start here. First, there was no, quote, hot pursuit of a fleeing suspect that would justify the warrantless seizure. Mr. Stearns was at his residence and fully cooperative with law enforcement when Detective Tangler seized his phone. He made no attempt to flee or evade the officers. We're at right here. Second, there was no imminent destruction of evidence. See Kentucky versus King. Detective Tangler articulated no specific facts suggesting Mr. Stearns was attempting to or about to delete data from his phone. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. The mere possibility that additional digital evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. They cite Raleigh versus California, whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. And then third is no emergency aid circumstances existed. They cite Brigham City versus Stewart. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. This argument fails. The emergency aid expectation requires law enforcement to have an objectively reasonable basis to believe that emergency exists, requiring immediate action to prevent imminent harm. They cite Missouri versus McNeely. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2000 hours on February 26th, yet Detective Tangler did not seize the phone until 1600 hours on February 27th, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was imperative. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Okay, I'm going to stop right there. But you have to do part of the investigation to find out that you need that evidence. I mean, it's taken 20 hours to even figure out that something suspicious was happening because they thought she was a runaway to begin with.
And they were just doing what I've always assumed what most investigations do in the early stages. They're questioning the closest people to the victim or the missing person, and they're trying to get all the information they can. And then they ask, can we see any information, especially if you're the last person to see them alive? Can we see your phone or any other kind of like technology that it might help find a clue to what happened?
Yep.
And then, in the process, if they find some weird, highly effed up stuff on your phone, then it sucks to be you, Stinky Stern.
Yeah. And he didn't do all of it. So his arrogance, it ultimately got his ass busted. Hey, Natasha.
But like I said, I get what his lawyers are trying to do. I'm just hoping. I personally feel it won't work, but I don't know. You know how these cases can be, where one little technicality can be, well, we gotta have to throw this out.
Yep, and that's what I'm worried about. That's my biggest fear of this.
Well, because then it brings up, the Delphi case, because that's one of my favorite things to talk about lately. But it's like, yeah, you can see how that judge will not allow certain things to, let's say, help in his defense, but she allowed all the prosecution crap. But then maybe in this case, it could be the opposite. They could just be like, sure, I mean, he technically didn't have this done for him or whatnot, but I'm hoping it's not like that. I'm hoping it's just, no, this doesn't make sense. He thought that he deleted everything off his phone. So the detectives just asked, can we see your phone? And he gave it to them willingly.
Yeah. Jollywood said, I don't know how many times my car got searched in the name of the Patriot Act. Come on, Florida Act. Really?
Oh,
I'm sorry.
Yeah. It's definitely that.
Hio said, he went to Northport and tried his best to get into Google Cloud to delete that shit. He was at risk of tampering with evidence. How can they not see that? That's a good point. That is a great point. That might be the basis. That could be something that the prosecution uses to say, we did have extended circumstances, because obviously we can prove that he was trying to delete the data.
That is good. Because they already started figuring out his driving antics, I'll say, early on too. So it would be suspicious why were you traveling on the opposite side? That what was it, 182 or whatever, when the girl supposedly disappeared on another side of an area, a different side. So I
Yep.
think that's a good point. What Heo brought. That's a really good point.
Yep. And the beginning of that interview that I played several times, they talk about all the places he was driving and stuff. So yeah. All right, back to the document, reading the rest of this page or what you see. Even assuming arguendo that emergency circumstances initially justified seizing the phone, this would not excuse failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. Lord of mercy, sorry. They cite State versus Foltz from 2016. Detective Tangler's own statements revealed the investigatory purposes behind the seizure, as she explicitly told Mr. Stearns, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" Unquote, demonstrating from the outset that her intent was to conduct a forensic search rather than to address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated. The officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates the true emergency circumstances did not exist. Detective Tangler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Scrolling down. Instead, law enforcement simply held it for over 9.5 hours before seeking consent for a forensic examination. This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under emergency exception, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within. And then I scrolled down. They cite United States versus Moss from 1992. This objectively reasonable belief must be based on specific articulable facts and reasonable inferences that could have been drawn therefore. See Mora versus City of Gaithersburg from 2008, citing Terry versus Ohio from 1968. Here, Detective Tangler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief in an emergency requiring immediate warrantless seizure of the phone. Oh, goodness. Lily said not his boxers, her underwear that appeared to be stained. Yeah, there were stains on hers. I'll look at that in just a second. Go ahead, Bazzer.
Yeah, I'm trying to remember that too. I just knew with his underwear in the laundry basket, and then the stains on the bed sheets. I don't remember stains on her underwear.
Yeah, I don't know. I could be wrong in that. There might have been. I know there were stains on the blanket and some on the sheets. There's a picture of her underwear that appears to show a stain, and that could be what I'm thinking of, but I don't know that they cite it. And it might not have been from that. It could have been from something else.
Okay. I mean, if it's there, it's there,
Yeah, but it might not have been from sexual contact. Women's underwear sometimes get stained for other reasons as
right.
What I'm thinking of, so I don't know that it was from that.
Right.
Heo said if they find DNA there, it could, but then again, could he have just been cleaning himself, etc., gross top? But it is what it is. Possible. Content Angel said the emergency exception to the Fourth Amendment means like the police don't need a warrant if a criminal runs in your house, or police hear a baby crying in the house, they don't need a warrant. Imminent, right?
Yeah, yeah.
So therefore, they can't state imminent danger because there was none, and they're right. Okay.
No, there was definitely danger.
Yeah. Hold on, let me see where we're at. Oh, I'm at the bottom of page 11. Okay, fourth. Yeah, we're at fourth. Fourth, there were no community caretaking circumstances requiring immediate action. The phone itself posed no danger to the public, and its seizure was clearly investigatory rather than for community protection purposes. Fifth, there were no exigent circumstances related to officer safety. See Maryland versus Bowie for 1990. The phone posted no threat to officer safety, and Mr. Stearns displayed no aggressive or threatening behavior that would justify its immediate seizure. Next, I've highlighted from there, starting right here. Detective Tangler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Stearns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly erroneous and negates any claims of exigent circumstances. Despite the well-established warrant system and the availability of emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this resource, further demonstrating the unconstitutional nature of their actions. Well, but he wasn't deprived of his phone because he had the other phone that his dad gave him. Right?
Yeah, he immediately let them know. Like, was it like, oh yeah, my dad had got me another phone or some bull crap like that?
Yeah. So he did have access. What did it say? He did have the availability to communicate with family members and access any of the other phone's essential functions.
Well, didn't he? I always thought from just remembering from memory past that didn't he already have like multiple devices anyway? So it would have been like, why are you so concerned about this particular phone when you have multiple other devices?
Yeah, he had his. I think he has a laptop. I know he had a desktop at his dad's house. I mean, the phone might have been the only thing he had at Jennifer Soto's house at that particular time.
Mm-hmm.
But it was, I mean, right after this, he's given a phone by his dad, as far as I know.
Mm-hmm. So, like, what? Like I said, I get what his lawyers are trying to get at, but in all of our minds and eyes, it's like, okay, it's all bullshit.
Yep. Yeah, everybody's getting kind of upset. I'm sorry, this is upsetting y'all. It's upsetting me too. I feel you all.
Of course, Lily. Of course.
Mm-hmm. Procedures trump justice. YouTube. Unfortunately, yeah. Unfortunately, yeah, because certain procedures are in place that have to be followed, even if and even for a particular reason. And if those procedures aren't followed, then yeah, justice might not be served. Unfortunately.
Because I guess you could say, well, of course you can say if it was an innocent person and they went through the same crap or situation, then it's like, well, you got found guilty on some weird technicality and you were innocent.
Yeah.
Mm-hmm.
Content Angel said the cops could get around this based off of what his father gave the police to see. We don't know that yet. If there was CSAM on the stuff his parents handed over, this motion is moot. And I hope that there was, but I think it says 3,700 images of other children. I don't think it cites that Maddie was in any of those images, but I could be.
Knowing him, he probably would have. Just these type of guys, they would keep multiple devices to keep like all their crap. So I'm assuming that probably there was maybe some stuff of Maddie at the home, the family, his parents' place. But I mean, even then, you can still get them on. I would hate it, but you can still get them on the other child material bull crap.
Yeah. Sandra said if his call log was empty, he obviously wasn't keeping contact with his dad. Good point. We are supposed to be boycotting US, but last night I dreamt of Perkins French silk pie. It's all I want. I love it. Making me want some. I saw Hio was talking about cheesecake. I want some of that. Verbal agreement is legally binding in the state of Florida, and she gave him a choice to hand over the phone or get a search warrant. How is that Stearns thinking he didn't have a choice? Because of the way she said it, Ashley, it could be because she said, are you going to let me search the phone or do I need to get a search warrant? Basically stating, I mean, you could argue that he didn't have a choice to say no because he felt like if he said no, they were just going to get a search warrant anyway.
And it kind of did sound a little bit like a threat in a sense. And they could say, yeah, felt like he was being threatened by authorities.
Yeah. YouTube said, I understand it's a slippery slope, but this is a child. Yeah, and that's so hard. Mercedes, we don't know. Sorry, go ahead.
No, I was saying, of course, YouTube. It's just unfortunately because of this technicality bull crap. It's just an issue right now.
Fawny said, I think the constitutional rights are what keeps emotions out of proceeding so that a fair trial can be given to anyone on trial. Imagine the alternative is mob justice, and that's not good. And you got a good point.
Yeah. I don't know. Sometimes I think, well, I know yesterday I was saying in chat, like maybe we need to bring back certain things. But, that does get into the whole constitutional stuff. And I do agree. If you're innocent, of course, you don't need to go through that kind of crap. But I don't know. It's very 50-50 sometimes, especially when you see cases like this or Evelyn or Naziah. It's like, should we really be fair to these people when it's clear as day they committed the crime?
Right. It's hard. But again, I mean, facts don't care about feelings, and
That's true.
That's what it boils down to. If there's procedural violations, I mean, our feelings don't matter, unfortunately. Dollyhood said maybe if they only use the data existing in Maddie's phone, I bet there's some incriminating stuff in there. I hope so. I mean, considering the circumstances, I hate that there probably is, but if they have to use that, I hope there's some in there. Going back to the document, I've got the first sentence of this part highlighted. When consent is obtained after illegal police activity such as unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. And then I've got this part, the first sentence right here. The fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. And then the next page, I've got the conclusion pretty much highlighted. And that'll be it for this document. And then the last document I have, I'll have to read to you guys. I mean, you'll have to watch the video. This one reads, the Google warrant and all that derivative evidence were directed products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree. Conclusion. Detective Tangler's warrantless seizure of Mr. Stern's cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communication device without consent or exigent circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. So that's that. The last document I have is the biggest one, and it's the motion to suppress evidence obtained from unlawful searches of cell phone. And you guys have to watch the video for that one. But This is upsetting. YouTube said dirty hands doctor and fruits from the poisonous trees with babies. No, just no, right?
Mm.
I wonder how he was on prescription Ativan with 2 days prior. He was asking his parents for anxiety meds. Good point, Ashley. Where was that Ativan at then? My phone was downloaded for a case I was involved in. What I was told is they can see and retrieve everything, and they did. Yeah, Stearns didn't know that. Thank God.
Yeah, he's such an idiot.
He is. Abella said when there are 1,700 sexual assault images of a child he obviously committed homicide on and 35,000 more disturbing, disgusting images, what effing leg does the defense have to stand on? Give me an effing break. Shut the fuck up, Stinky.
Yeah, I guess they think, well, somehow there's probably, this is what I'm guessing. They think if they can get the Maddie part when it comes to CSAM material off of him, that will somehow navigate. Oh, there's a train.
I know, it's okay. It's the crazy train going to Speculation Station.
That IRL one. But yeah, I'm assuming that they're trying to say that the other disgusting material would be, I was trying to use negative, I can't even say it, not used. And that's somehow going to benefit him, but I don't think that's even going to work. Even if they can get this Maddie stuff, which I hope they don't, he's still got other freaking disgusting crap with children. So it's like, where do they, I don't know what they think that will do on that part.
Yeah. I mean, I think the charge might be less and the I don't know. It's a good point because regardless, like you said, he still has the images. So I wonder, I don't know if that would lessen the charge or not. It seems like those images are worse considering bestiality and children like 18 months old and shit.
Right.
So that's a good point.
Is it, well, because, is it because they think if they can get the Maddie stuff off, it'll, because I don't know if he's going to have the same lawyers, I'm assuming, for death penalty case or the murder trial, that will somehow help in their defense of him. Like, well, you can't prove that he did kill her or not because of X, Y, and Z. And I'm like, okay, even if you did get the CSAM for her, you still have the fact that he aided and abetted in the disposing of her human corpse. Now, why would a person who is a child molester, who supposedly is innocent of murdering his favorite child, like how is that? That's not going to help his defense case. Like, no, it's like, okay, why did you have a dead body of the girl that you supposedly cared about in your car? Why did you keep her hiding for a while and then you drove to a spot that you dumped at a place that coincidentally Maddie and Jen had been to before?
Yeah.
Well, this is my mind exploding. Like, see, this doesn't make sense. How is this going to work? But that's his defense lawyer, so.
Yeah. Sandra said it would remove the death penalty in the other case. I was thinking that, but I think you could still prove aggravating factor because of the CSAM that he had of the other children. Because at first I was like, well, it would remove the death penalty in the other case. But then again, I mean, he still had the images of the other children, which appear to be worse. So that would be aggravating factors. Bellis, thank you so much for gifting 20 memberships. Girl, it's your birthday. I'm supposed to be gifting you. Thank you. Those went to Lucy Season, RL Froze, Pink Burst, Your Best Nightmare, Ashley, Yawn and Greyhound, Philly Girl, Rachel Lee, Shining Star, Amanda, Keeping It Real, Tara, Akira, Miss Ella, Squish, Molodak, and Linda Little, Leon 1011, Leon 1010. Sorry. Thank you for that. That was so very sweet of you. If you guys were gifted a membership from Abellis, please tell her thank you and also happy birthday. I'm gonna come pick y'all up on the crazy train headed for Speculation Station. Thank you, Abellis.
Happy birthday again, Abellis.
Yeah, I'm gonna play her song again. So if y'all got if you got headphones in, or turn them down, or like turn your TV down if it's up real loud, because I didn't get to turn the volume down on this. This is for you, Abellis. Happy birthday.
Happy birthday to you.
I think that is so cute.
There's some good dance moves right there. I'm impressed.
Uh-huh. He sure did, didn't he? That little elephant.
I actually thought it was an anteater at first, but now I can see the elephant.
Oh, it might be an anteater. I don't know.
They all look alike. Not all right.
Oh, goodness. Well, I'm going to have to go for the day and get that document video out for you guys. I appreciate you coming up, Bazard, and sharing.
Yes,
your
yes.
thoughts.
Yeah, I know it's been a minute. Just work has been on my end and just hasn't been able to get me on the panel. But yeah, it was always nice to get on and chat and discuss about our idiotic Stinky Stearns and make sure that he'll get his due justice, because I truly believe it will happen. But we'll just have to, see how things progress.
Yeah. I hope that I hope that the judge sees through this bullshit.
Mm-hmm.
Excuse my French. Abellis,
No.
that's not French. Carolina said, I'm not going to be bothered by the defense motions. I'm going to stay positive and pray that sweet, precious Madeline will receive her justice. Me too.
She will. I truly believe that with all the bullcrap that his defense is doing, like I said, sure, whatever, it's their job. He's going to get found guilty. There's no if and buts, people. All of us know that he's going to get found guilty, and justice will be served.
Lord, let us pray.
It will. And then, of course, the next thing is always what's going to be with Jen. But I personally think something will happen to her. There's one way or another karma, either by human hands or by other hands, will come to her as well.
I hope so. I really think that she had a lot more to do with this. And it's, again, going to fall down to what can be proved in court.
Mm-hmm.
Ashley said, so are you saying even though Stearns gave law enforcement his phone without being coerced, law enforcement would have to come back and get his consent to look into Google all of his apps? That doesn't make sense. Basically, yeah. They have to ask specifically to do a search warrant for all of his phone data. I mean, they could say that and it'd be okay. I don't know.
Mm-hmm. Like I keep saying, I think it'll just come down to the judge deciding, well, your client said, because he believed that he deleted everything off his phone, that is fine. So that's how I feel it'll come down to that.
Yeah.
Maybe the authorities kind of, sort of, I mean, she did, I remember hearing it. Yeah, she kind of did sound like she was threatening him in a sense, but he thought that he deleted everything. So, come on.
Right. Lily said, I do love that really large channels are covering this. She'll never lead a normal life. Yeah.
Oh, yeah. Oh, yeah.
Even if
she's done. Mm-hmm.
Mm-hmm. All right, y'all. Thank you for hanging out with me today. I hope y'all have a good day. Make sure you hug your babies, hug your children.
Mm-hmm.
And thank y'all for listening to me read documents and go through this evidence with y'all. I was really bothered. I feel a little bit better, but I mean, I didn't know what to think.
Mm-hmm.
Reading that stuff.
When I caught up on when you read the terrible, things that they did find on several images and videos. Yeah, it's hard. And that was one reason why I want to get on panel and talk about how I just hope that this doesn't, go through. But you did a good thing. I know it was tough, but you went through it, and yeah, I just appreciate how you just do what you have to do, Alleged.
Oh, you're so sweet. Thank you. I appreciate
You're welcome.
hanging out.
Mm-hmm.
I thank you for coming up for sharing your thoughts.
Oh, anytime when I can. Anytime when I can.
I hope.
But I'm sorry.
No, you're good. I said I hope work's been going okay. I didn't mean to interrupt you. I sincerely apologize.
Oh, no, no, no. It's just several unfortunately individuals have gone to the other side, but that's just part of life. But
Oh
it's just
man,
a workload. Yeah, you know.
I'm sorry.
Yeah, yeah, but it is what it is. And I always appreciate at least this being there for them and their families and their time. And of course, you know, that there's always someone else that they'll send me to, and I'll just be there for them.
Yeah, it's got to be hard though.
It gets to you. It does from time to time. But other than my work life, I hope you enjoy the rest of your day with your family, like you said. And I'm gonna be heading off right now. And
Okay.
take care.
All right, you too, love. Thank you for coming up.
Bye bye.
Bye. Thank you guys for hanging today. Let's please say a prayer that this motion does not go through and that Maddie gets justice. I do have concerns. I'm going to read all the documents for you guys so you can check out that video. If you want the documents unwatermarked, they are on my Patreon. If you see Abella's in these YouTube streets, please tell her happy birthday. And I hope that your day is as special as you are. I love all of you so much. I love hanging out with our Speculating family every single day and talking about these cases. Yes, Bonnie, I do believe so, from what I understand. Y'all have a good day. Stay safe. And make sure you hug the babies. Tell people you love them. And I'll see y'all tomorrow. Bye.